Therefore, also liberty to list the matter on Monday for motion item, but it's regularization.
Monday on for motion.
For motion. I'm good from Manu.
Wait, please, Your Lordship. Lordship, with due consent of the other side, I beg to mention item number 39 of today's daily list, Lordship. This matter has come for the second time, my lord. We have to file our affidavit in opposition. I have written, my lord, so I'll be filing it within 2 weeks, my lord. So I'd seek some accommodation today, my lord.
When the matter reaches.
My lord.
Similar prayer, Lord.
Please, Your Lordship. With respect to item number 27, Your Lordship, the matter has become instructions, Lordship.
I am for S1 and 3 and for us.
HR Das.
Lordship.
Mr. HR Das, the learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous.
I am for S1 and 3 and 4.
Mr. NJ Gogoi appears on behalf of the Assam State
Assam State Agriculture Marketing Board.
Agricultural Marketing Board. Taking into account the above, the writ petition therefore stands closed as it has become infructuous. Interim orders, if any, stands vacated.
Public.
I for listing of Monday, 4th February.
Or
February.
why? Orders, motion,
Admission.
4th of February. Oh, why?
February.
Next week is February.
Yeah.
Why?
Teacher in very soon, Lord.
When?
There is 6 months.
6 months. Time is there. 16th February.
May I appeal, Lordship? Lordship, this is the application for withdrawal of one writ petition, my lord.
Monday.
My lord, and another is for admission, my lord, for listing, my lord. Next week, any date, my lord.
18th February.
My lord, deeply.
Motion 20 February.
May it please your lordship. Your lordship, I pray for listing of a matter on Monday, your lordship, for orders.
Orders.
Yes, your lordship. It was a transfer matter. Obliged.
I get to mention for listing of a writ petition for admission column, my lord. Matter parties to my lord, retirement benefit, sir.
9th.
Much over.
May I please, Lordship? I beg to mention for listing of a matter, admission matter, medical reimbursement bill. The list,
13th.
I love that.
How many matters? Only one. You have too many papers with you. Okay. One more. Okay, 18th February.
May I please, your lordship? Lordship, I beg to mention item number 25 of the daily list, lordship. Lordship, in this matter, I am praying for adjournment of lordship.
Where for?
Petitioner, lordship.
Name?
K. Kashyap, lordship.
Mr. So-and-so seeks for an accommodation. List the matter after 4 weeks.
My lord, I have similar prayer, lordship. Item 43, lordship, with the consent of the other side. Item number 43, lordship.
53,
43.
46.
43, lordship.
Huh?
43. 43,
43.
lordship.
51 is otherwise impact because they preferred review, my lord, against the appointment of Daura.
Then,
They filed lead petition. Review has been hard yesterday, my lord.
what do you want?
Lordship, matter may be fixed.
You have filed a review and you are keeping this matter pending out here.
Yeah.
Duplicity of proceedings. No, when we have the matter, we'll treat. Make that up.
56, fixed at 10:30 AM, personal appearance to your service.
But here instruction this, huh?
Instruction is given.
Video to on karo koi dia.
এইটোৱে কৰিবা second time তাইক হেৰি কৰিছে সাসপেনশন কৰিছে second time সাসপেনশন কৰাটো লোৱা আছে they need order to be right 28 order to প্ৰথম 28 order to
So this was done. So you have conducted a review meeting?
Malad, the order was issued on 22nd of December 25. So that period has not come. But because
22nd of December
December.
2025.
page number 39, Malad.
Page number?
Page 39 in the writ petition.
So you have earlier conducted an inquiry.
Lordship.
Now the inquiry later on you found that the witnesses were not properly examined.
Lordship.
Now you are going for a fresh inquiry.
Well, the inquiry officer has already been instructed and he is going to submit a report. That
So what is the stage of the inquiry?
But the report we have not received. As per the instruction, well, that report we are awaiting. The inquiry officer is going ahead with the inquiry. Well.
Now tell me one thing. The department appoints an inquiry officer.
Malad.
Does the inquiry officer have any independence on the inquiry proceedings, taking into account that at the midst of the inquiry, you say that these things are not there and therefore you want to have a de novo? My only question is this.
No, in fact, Malad, the inquiry report was submitted. No?
The instruction which appears,
Malad.
kindly see the second one from
Lordship.
the joint secretary to the deputy commissioner.
It said that subsequently the inquiry
List
reports.
of witnesses appended with the show cause notice, the names of two witnesses are recorded, Sri so-and-so and the team of vigilance. During the course of inquiry, the statement of the listed witness have not been recorded. Instead, statement of two non-listed here. Further, the DP charge did not contain the list of documents relied upon. It is also not known from the inquiry report whether the DO was given the opportunity to cross-examine the witness. It is worthwhile to state that such procedure here will make the departmental proceedings vulnerable to judicial, thus placing the government in an embarrassing position.
Lordship.
So therefore the question is it in the midst of the inquiry?
No,
The
The-
inquiry report has been given.
report was given before taking a final decision on the report. The entire records were sent to the department. At that stage, my lord, ultimately from the available record, this was observed.
So you are going to have a fresh inquiry.
Lordship.
So the inquiry has happened and now you have, hence it
It-
appears
it
the
is not a-
procedure in the conduct of DP in the instant matter and thus it is directly instruct the inquiry to conduct a further inquiry.
It is a further inquiry, my lord.
Following the proper procedure as laid down in
Yes.
so and so.
Lordship.
The list of documents relied upon may be shared with the delinquent and he may be allowed to examine the same if he wants after conducting the inquiry. Within what is this, 4 months?
Within possibly it is a typographical error, my lord. 4 months, man.
Yes, Mr. Chaudhary.
My case is what you watch, it's initial suspension was set aside. In a criminal case, he was arrested for deemed suspension, 6-2. Thereafter, he was asked to, he was posted in a different place. I joined. Thereafter, my lord, after joining, that after when I was to serve my duty, then this second suspension was.
Now, the second suspension order is a product of 61C.
See, the same thing, my lord, who is a criminal case, deemed suspension.
No. 6.2 is different. 6.2 is pertaining to a person being put under, behind the bars for more than 48 hours. So that is 6.2. So that is another thing. But it 6.2, if a person has been released on the ground of certain procedural technicalities and all, now the power to suspend still continues under 6.1C.
No, that's already calm, man, suspension, see, in connection with the criminal case, man, what she says, man, can you talk to say? That
There's
is
a
also-
criminal case against you.
It is there, but on that ground, because deemed suspension. See, if everything is-
No, Mr. Chaudhary, the deemed suspension cannot be on the basis of that. Deemed suspension is a person who is arrested and kept behind bars for 48 hours. Now, the moment you are released, then within 90 days, they have to give you the memorandum of charge, and these are all these technicalities which are there.
Right.
But I am not on that. C61C. 61C categorically mentions that if there is an inquiry, trial and all which is going on, then in that regard, the disciplinary authority have the power to put you under suspension. So your suspension thereupon which is being done in view of the change in the circumstances, this court at this stage can't interfere. Wait for some time. Wait for another 3-4 months. Therefore, I asked you whether there is a review. Now the review has happened. It is freshly suspended, taking into account the charge sheet has been submitted and the sanction having been granted for prosecution. Wait for some time. After 3-4 months, then you can very well again come before this
No,
court.
can you see, man, what he said, just
See.
where a case against him in respect of any criminal offense is under investigation. Inquiry or crime. So the same thing initially might have when that I was released on bail. That also inquiry is going on. At that time also, because we started criminal proceeding started by. Here also my proceeding started, then because of procedural less, it was set aside. Now, what is the purpose of second suspension, my lord? I am not in the same office, my lord. I have no access to that office also. I am in another office, my lord. Far away from the main office, my lord. So what is the purpose? One day what they are saying, my lord, C, I do not find a difference between C and 2, my lord, because though it is 48 hours, but in connection with criminal case, my lord. And that inquiry is going on. Till then, that very day when he was, my lord, released on bail, my lord.
What do you want? Dismissal?
No, my only question, my lord, kindly see what is this purpose of the second suspension?
Second suspension is there. This is done under 61C. Yes,
Yes, right.
if it is unreasonable, we will interfere with it. But as of now, I don't feel it to be unreasonable at all. They have done it on the basis that 61C, now there is a prosecution sanction given against you. They want to keep you under suspension. Come up after 4 months. We'll look into this.
But keeping suspension is, my lord, what purpose will serve, my lord? Because already set aside.
What purpose will serve or not, that we'll see after 4 months, not now.
My lord, once your worship may let us see something.
Come up after 4 months or 3 months, 90 days. And then question it on the ground that whether it is reasonable on them to keep you under suspension after this period. Because
So-
4 months is the period for the disciplinary proceedings to be completed. And it started sometime in the month of December 2025. Up after in the month of
22,
April.
12.
April?
But what?
You are
they-
going to get 50% or 75%?
That will follow.
You are getting
Because
your
it is under
subsistence
suspension
allowance
for-
or
No,
not?
that I have already joined, my lord, resume my duties and. I
Then
have-
now are you getting your subsistence allowance or not?
Now do only hardly 1 month, my lord, because.
Okay, you will
this
get your
is not
subsistence
complete.
allowance.
So this month.
We'll look into it later on,
So
not now.
22/12/25 this suspension, my lord. But what is their symptom, my lord? Just your worship kindly see, my lord. In compliance with the instruction contained in letter number so and so following orders are hereby issued. Now, as the ACP police says against so and so, Shri Sompatacharji, is under investigation. Correct. So and so is hereby placed under suspension with immediate effect of section 616. Can a person be put under same kind of suspension 2 times? Under section 6, my lord. Once in under 2, C2, that is also relating to criminal matter investigation. The second one is also, my lord, a criminal trial.
From
So,
what
my
I,
knowledge about your worship,
Mr. H.R.A. Chaudhary, this is the very good case for the division bench to look into it. Let me dismiss your petition right away. Because this is a question which requires an adjudication by the division bench. Let it be decided. From my limited point of view, you can be further suspended under 61C. You can be suspended even if you have been reinstated in view of the technical. For the reason that now there is a change in circumstances.
my lord, let them say in writing, my lord, because
This
what
is
is,
already there on records. It is not going, Mr. Chaudhary, this is not going to change the situation
will
out
not
there.
say so.
If they say
that
also,
was your worship decide on merit.
I'm deciding on merit only, right? Heard Mr. H.R.A. Chaudhary, the learned senior counsel, assisted by so-and-so, appearing on behalf of the petitioner. Mr. D. Nath, the learned senior government advocate, who appears on behalf of the respondent number 1 and 2.
Two, my lord. I'm for
Respondent
two.
number 2. You appear for respondent number 1. Full stop. Wait. Mr. Deputy Commissioner Kachar, I want to ask you a question. When this court issues a notice 6 and instruction from you, why don't you inform your advocate about the fact that why you have done this? We have no intention of calling you on a video conferencing line. If you had received the instruction, it was duty bound on your part to intimate.
Sir, good morning, sir. Sir, first of all, actually, this was, I think, a case of miscommunication, both between the our office and the government advocate's office. So a communication was sent from our office on 19th of January, but to the government advocate's office, but apparently it was not placed on record in the last hearing. So, sir, if you could please overlook it as a case of
Okay.
miscommunication.
I've seen it. This instruction is on 19th of January.
It was a
It's okay.
miscommunication. my lord.
Because this was not pointed out before this court on the 28/1/2026. In fact, the government lawyer who appeared before this court said, although instructions were sought for, no instructions were given. That's the reason why we called you. Anyways, yeah.
Noted, sir.
Mr. So-and-so appears on behalf of Mr. So-and-so, the Deputy District Commissioner Kachar is present pursuant to an order passed by this court on 28/1/2026, present through the video conferencing link. Full stop. The petitioner herein have challenged the order of suspension dated 20/12/2025. Primarily on the ground that the petitioner earlier was suspended
Page 22.
on the ground of on being arrested in connection with ACB PS case number 47/2024 in terms with Rule 6(2) of the Assam Service Discipline and Appeal Rules 1964. For short, the rules of 1964. It is the further case of the petitioner that the learned coordinate bench of this court by an order dated 26/5/2025 in WPC number 659/2025 had set aside the suspension on the ground that it was in conflict with the law laid down by the Supreme Court in the case of Ajoy Chaudhary versus so-and-so, reported in so-and-so, as well as Rafed Ali Ahmed versus State of Assam, reported in so-and-so. It is the further case of the petitioner that on the basis of the order passed by the learned coordinate bench of this court dated 26/5/2025 in WPC number 659/2025, the petitioner was reinstated by an order dated 9/6/2025. All of a sudden, on 20/12/2025, the petitioner was again suspended. Mr. H.R.A. Chaudhary, the learned senior counsel, appearing on behalf of the petitioner, submits that the respondent authorities, having already suspended the petitioner earlier and the said suspension having been set aside, now, in terms with Rule 6(1) brackets 6 brackets 1 bracket small c of the rules of 1964, cannot again suspend the petitioner. The learned senior counsel submitted that the fresh the impugned suspension order dated 20/22/12/2025 is nothing but overreaching the orders passed by this court, whereby the suspension order was set aside. Per contra, Mr. D. Nath, the learned senior government advocate, appearing on behalf of the respondents, number 2, submitted that the fresh suspension order, the impugned suspension order, is an order passed in terms with Rule 6(1)(c) of the rules of 1964, whereas the petitioner was earlier suspended in terms with Rule 6(2) of the rules of 1964 on the ground that the petitioner was arrested and was in custody for a period of more than 48 hours. The learned senior government advocate further submitted that in the meantime, their circumstances have also changed, inasmuch as a charge sheet has already been submitted and there is a prosecution sanction being granted against the petitioner. And it is under such circumstances, a fresh suspension order has been issued in terms with Rule 6(1)(c) of the rules of 1964. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record, including the instructions which were placed by Mr. D. Nath, the learned senior government advocate, which is kept on record and marked with the letter X. A copy of the said instruction is also being handed over to Mr. H.R.A. Ahmed, the learned counsel who is assisting Mr. H.R.A. Chaudhary. Rule 6(2) of the rules of 1964 reads as under. A perusal of the above rule reveals that, shows that when a government servant is detained in custody, whether on criminal charge or otherwise for a period exceeding 48 hours, the government servant shall be deemed to have been suspended with effect from the date of detention by an order of the appointing authority and shall remain under suspension until further orders. At this stage, it is very pertinent to take note of that this court, while dealing with a situation as regards the applicability of the dictum of the Supreme Court in the case of Ajay Chaudhary, Supra, passed a judgment reported in the case of Rafet Ali Ahmed versus the state of Assam, reported in 2023, 3 GLT 718, wherein it was held that a period of 3 months, if within a period of 3 months from the date of the release from the detention, from the date the intimation is provided about the release from detention, the memorandum of charge the charge sheet is not served upon the delinquent employee, the suspension would be in violation to the law laid down by the Supreme Court in the case of Ajay Chaudhary. Full stop. This court now, in the backdrop of the above, it is very pertinent to take note of that though the petitioner was suspended on 18/6/2024 with effect from 12/6/2024 on the ground that the petitioner was arrested and detained in custody. But the petitioner, upon being released on bail, and the intimation duly being provided, the respondent authorities did not serve the charge sheet the memorandum of charge within the period of 90 days from the date of the intimation. It is under such circumstances that the learned coordinate bench of this court, by the order dated 26/5/2025, had in WPC number 659/2025 had set aside the suspension order as well as the consequential orders passed. And directed that the petitioner be reinstated within a period of 15 days. Pustu. It further appears from the materials on record, more particularly the document which is kept on record and marked with the letter X, that in the meantime, the memorandum of charge has already been served upon the petitioner and an inquiry proceedings have been initiated. It is further seen from the communication dated 18/12/2025, issued by the Joint Secretary to the Government of Assam General Administrative Department to the respondent number 2, that there were certain defects noticed in the departmental inquiry proceedings, and as such, the inquiry officer has been directed to rectify those mistakes, thereby giving further opportunity to the petitioner to participate in the said inquiry proceedings. It is also noticed that in the meantime, The charge sheet in the criminal proceeding, isn't it? I saw it. Charge sheet in the criminal proceedings have been submitted.
Our information not submitted to our information.
Okay.
Pending. Also,
Taking into account that the proceedings that the
This is an idea.
taking into account that in the meantime, the inquiry proceedings, the departmental inquiry proceedings is ongoing. The judgment of the Supreme Court in the case of Ajay Chaudhary, as well as Supra, as well as Rafed Ali Ahmed, would not apply. Inasmuch as the petitioners have already been inasmuch as the department proceedings is presently ongoing and there is a direction upon the inquiry officer to complete the inquiry proceedings within a period of 4 months. This court have also taken note of the reasons were assigned. In the impugned order of suspension. And it is the opinion of this court that to interfere with the suspension order at this early stage on its reasonability and rationality would not be in the interest of justice. Under such circumstances, this court is therefore not inclined to interfere with the impugned order of suspension. Dated 20/22/12/2025. Be that as it may, the liberty is, however, given to the petitioner to approach this court in the circumstance the said suspension order is extended beyond 90 days. Impugned suspension is extended beyond 90 days on its reasonableness and rationality.
If so desire, the desire.
I'm giving him the liberty.
Lordship.
Liberty is always as per his desire.
Lordship. Follow.
One thing I
All
must point out that he was posted in another place that was not mentioned by.
It's okay,
Right,
but
right.
as of now, I'm not looking into it.
Yeah.
I'll look it later on, after 90 days. By February, you come.
Or suspension announcement of your worship.
Huh?
Suspension announcement.
If you don't come,
That
he's
as per
always
rule,
at
that as per
liberty.
rule, Malad, definitely he will get.
Mr. HRA Chaudhary, don't spoil his practice. He wants to come again and again, Mr. E. Why you are spoiling his practice? He let him come and file another writ petition for subsistence. Huh?
For giving him a chance for this.
Yes, give him chance.
Obliged to.
I'm therefore keeping the ear open.
He'll be busy with some other activities, Lordship. He will be busy with some other activities for next 2 months. That's why he do not want to come in the middle.
No, that's why he is our combined.
Modern হয়ে গেল?
Mr. Advocate General, it reminds me of the Assamese fable, Bubu's Rajha. Bubu's Rajha. He took all the eggs at once. Yes, tell me.
Regarding my.
Mr. Counsel, first of all, tell me, your representation certified copy, 4 months from the date the certified copy is to be served, isn't it? That's the order. When did all these persons receive it? There's only one signature. 4/11.
Submitted to the office.
Understood. It is only received by only one person. Where is the others? Why are you making other people parties? We are not going to issue notice on the Health and Family Welfare Department of Finance. No. Only, and you have not made him the party, the director of pay to whom the notice was issued. Health Service. You have issued this communication dated 4/11/2024 to the Director of Health Service. Isn't it? Now, if you have issued, where is he a party here? Number 4, number 3. Okay. Who is the Medical Health Department Council? Anybody? You are there? Health Department?
From the Standing Council, Health Department, Lordship.
Okay. Ask him to obtain instructions. And we are not going to issue notice upon these 4. Only to this health. These are all health and finance. This is also I am not issuing it. Get hold of the Health Council, madam.
Lordship,
We'll take it up after some time. We'll get an instruction why it is not done. Yes.
We are challenging the selection of the public prosecutor, additional public prosecutor and assistant public prosecutor. Now, appointment orders have not been issued, so the process is on. Now, basically, if a lordship would kindly come to the advertisement.
Advertisement where?
It starts at page number 109, sir.
Okay. Ah,
Please come to 112.
yes.
Clause 8, documents to be submitted. Please come to Roman 4 minutes. Document showing date of enrollment with a self-declaration that after enrollment, BC has not left practice as advocate and has not joined any other service, profession or business. Lord, I have referred to this clause to show that many of the respondents, despite the fact that they have left the practice, somebody even became a member of Foreigners Tribunal, etc., yet they have been shortlisted. That's number 1. Then Milord will kindly come to next page, Milord, 113. Selection process shall be as per relevant provisions of the Assam State Prosecution Service Code. So there is a statutory rule which governs the Milord selection. Now, before I take your lordships to the rule, please come to page 116. Kindly see, Milord, how perfunctorily things have been done. Please come to serial number 5 and 6. While issuing the call letter, Milord, these two, amongst others, these 2 clauses were incorporated. Every candidate shall be required to produce before the selection board at least 1 copy of any application petition appeal drafted by the candidate himself herself and filed and registered before a court of law in any criminal proceeding. That means one of the pleadings has to carry. Number 2, 6. Every candidate shall be required to produce before the selection board 4 copies of any order, judgment passed by any court of law in any criminal proceeding in which candidate himself herself appeared, conducted, and argued the matter. My lord. Anyway, my lord, what I am trying to show from this is, my lord, there was no written test, only interview. Now, my lord, if this requirement would have been insisted upon along with the application form, then a contemporaneous record could have been maintained as to whether they have this qualification or not. Now, my lord, there is nothing. Now, who has maintained the records of interview? There is nothing. Then the Lord will kindly come to
Means,
now.
I didn't understand.
What I have trying to say is, now, this requirement envisaged in 5 and 6. Had it been a clause which would have mandated that while submitting the application, this should also be accompanied. In which case a record could have been maintained. Well, not today, there is no written test, no nothing. Only on the basis of interview, this selection has been made. Now, how do we verify whether they carried this or not?
But you can verify whether they had these 4 judgments or not.
No, Mila, how can we, Lord? He only knows Mr. X is an advocate. He has conducted some case. How is it possible for public at large or the applicants at large to know, Mila? No, there is no means to verify this. That is what I am submitting, Mila. And
Okay.
these are only part of it. Now, Milord will kindly come to the rules. This is where, Milord, at 139, the rule starts at 133, Milord. Please come to 139. Rule 19.2.
Yes.
Evaluation of candidates with substantial experience for highly skilled role, like public prosecution, would require a specialized testing for assessing the requisite qualities, drafting skills, analytical and presentation skill, mental agility and quick grasp of arguments, and quoting judicial precedents, etc. Accordingly, the selection board may devise appropriate method of proficiency come skill test by conducting viva voce. So only mode to test the the eligibility of a candidate is viva voce, no written test. Then please come to the next page, page 140. After holding the examination, selection board shall select the candidate in order of merit, taking into consideration reservation for SC, ST, OBC, etc. Now, my lord, our whole grievance is actually, my lord, we filed a petition before the division where we also challenge the virus of Rule 19.2 because we want to say, my lord, in other states they are also insisting on written test apart from the interview. Now, interview means 100% is on interview, my lord. If we go by the line of cases starting from Ajay Hasia, where Supreme Court says, my lord, in any case, the interview component should not exceed 12 or 15%. Now here 100% is on 50%. Now, if we read, my lord, today I am not laying a challenge to the rules that which we are doing separately because liberty has been given to us which we are doing. When we brought out to the notice of the Honorable Court that this is an appointment in posterity, that means these people will continue. It is not for a, my lord, period of 2 years or 3 years. At the end of the day, they will be paid from the, my lord, state exchequer. Now, question is, how do we verify in this selection process that these norms were followed? What is the means to do it? That's why I said, my lord, that the requirement at 5 and 6, if they would have insisted that it should be part of the application form, that it would have maintained in the record. Now, my lord, even if I want to allege that X would not meet this requirement, how do I prove it, my lord? So this itself is, my lord, arbitrary. There is a scope, and there is no cut-off mark, and most pertinently, my lord, for 241 appointments, 7,000 candidates were invited. My lord, normally for interview 2 to 3 times. If we go by the preponderance of the view of the Supreme Court on this aspect, my lord, of service jurisprudence, Supreme Court says 2 to 3 times. Now here 7,000 candidates were invited, my lord.
7,000 must have applied.
My lord.
7,000 must have applied because it is an open advertisement.
Merely because there is an application, there is no requirement to, that's why, my lord, written test is necessary. In fact, when High Court conducts grade 3 and grade 3 examination, my lord, first there is a preliminary examination, followed by written, followed by interview. Here there is only interview.
But Mr. Chaudhary, you have fallen into the trap of the division bench. And you have come before the single bench without insisting by giving up the challenge to the rules. No, you are saying, not here. That rule which is there, that rule I can't touch it as it is, I am looking into it.
So all that I want your lordship is to read 19.2 and 19.6 harmoniously and try to find out from the records whether it was followed. Rule 19.2 and 19.6 as it stands. So, my lord, the selection proceeding record must establish, must demonstrate that this aspect as indicated in 2 was given due consideration while selecting the candidates. And my lord, nobody knows, my lord, there was no video recording, nothing. We do not know how much time was taken to test the, the candidates.
Let us see the advertisement once
Yes.
again.
Advertisement is at page 109. My lord, at this stage, what I am asking for is, my lord, I am not even praying for stay of the appointments, my lord. That can always be made subject to the outcome of the case. It starts at 109. My lord. For example, for public prosecutor, and it's similar, educational must be a graduate with bachelor's degree in law from a recognized University of India and or institution recognized by Government of Assam or University Grants Commission. By essential qualification must have practiced as a regular advocate for not less than 8 years, including practice before the High Court, basically on criminal side. So these are the requirements. Right. As far the educational qualification is concerned, my lord, there is no difficulty. But only thing is, my lord, Rule 19.2. In the absence of, my lord, any written test, the contemporaneous record must reveal that this requirement was insisted upon and selection was done accordingly. All norms of, my lord, selection were flouted. There is no question of interviewing everybody. Somebody must come within, my lord, some parameter. There has to be some form of scrutiny.
How many members, how many persons participated for this foreigners tribunal? No written test.
Sorry.
Eh? Uh-huh.
And my lord, we could lay our hands to rules of the other states where they are insisting on written test. A written test would have, my lord, given more credibility to this process. Now we do not know, my lord, what were the objective materials for arriving at the subjective satisfaction that X is good, Y is bad.
So select list published,
No. My lord, they have shortlisted.
or provisionally
241
selected
candidates.
for a year.
No, it is done. We have made them parties also. We have made all of them parties. 125. In fact, my lord, when we filed this, there were 299 because there was overlapping. If candidate's name appeared in either of the 3, therefore now I think recently, after filing of the petition, they have brought it down to 241. So that means 51 additional.
So there are 26 public prosecutors, 88 additional public prosecutors.
Possibly may not district wide.
Oh, these are district wise? No. Then
299 was the advertised post.
again, 181 assistant public prosecutors. What is this? There are two select lists. At 126 is one,
Yes,
and what is this 129? 28?
once.
Oh, this is
Assistant
assistant.
public
Additional public
Public
prosecutor.
prosecutor, additional and assistant.
So your argument is that Rule 19(2), although without prejudice to your right to challenge it, was also not followed. That is your first
Yes,
leg of
and
argument.
the
Secondly,
records would reveal, my lord.
the advertisement was framed up in such a manner there cannot be contemporaneous records maintained. These are the two.
These are-
And this facet therefore would show that there is an arbitrariness or there is a chance of arbitrariness.
Precisely.
That's your argument.
Absolutely, lord.
So one very important submission has been made that they are not pressing for any stay. They are not pressing for any stay. So if Lordship is pleased, because lot of questions has been raised,
Only
that where the records are kept, all these questions are raised, we'll have to give on factual, on affidavit.
Okay,
Yeah,
there's no problem.
now let me do, apprise this honorable what happened. Advertisement was issued and we have got about 7,000 candidates. This interview continued for about 6-7 months. 3 committees were constituted, 3 selection boards, headed by 3 honorable retired judges, and all other persons are well qualified as per the law. So there is no discrepancy. Proper interview was done. Sufficient time was given to all the persons, and the select list were prepared by the 3 selection boards. They collated it, and it was opened by them in front of all the officers. So if Lordship wants, all the records we are ready to submit, number 1. So far as the 4 writ petitioners are concerned,
How many petitioners are?
I think 4. The advertisement was issued on 5th of January 2025. And today, 2nd of January 2024, advertisement was issued.
A Pinata Naide. 2nd of January.
2nd of January 2024, the advertisement was issued.
24.
Yes, Lord.
24, 25. 24. huh?
Yes, 2024.
Yes.
Now we are in 26.
2 years.
So everything was there. They participated in the interview and the select list was issued on 21st of November 2025. And they have filed this writ petition on 5th of January 2026. So there is sufficient and substantial delay and laches on the part of the writ petitioners. Huge delay. If they were aggrieved by any of the rules, it was in public domain, it was duly notified in the official gazette. They should have come immediately. They were sitting idle and they have participated in the selection process, appeared in the interview, and when they are found that their names were not there, they are unsuccessful, they have lost this case. That also after delay of about 40 days. On 21st of November, we issued and they filed it on 5th of January. So another 40 days delay. There is 2 years delay, then 40 days. The allegations which they have raised, we have to go by the rules. If anybody is found that they do not have the eligibility criteria of having 4 years, 5 years, and 8 years in different categories of post, they can be chucked out. There is no difficulty. But the interview board, after considering every detail, they have indicated in paragraph 22 some of the instances. Page 67. May I just read this paragraph? That the petitioners beg to state that in gross violation of clause 8 Roman 4 of the advertisement dated 2/1/2024, several candidates who were already serving as member of Foreigners Tribunal under the government of Assam and who had thus admittedly left regular practice as advocate and entered into government service have been illegally selected and appointed as public prosecutors, additional public prosecutors, and assistant public prosecutors. The advertisement explicitly mandated that every applicant must submit a self-declaration affirming that after enrollment as an advocate, she has not left practice and has not joined any other service, profession, or business, and further warned that discovery of any contrary fact would entail rejection of candidature or termination from service. It is submitted that despite these mandatory stipulations, the following candidates who were previously appointed and served as Foreigners Tribunal members, as evident from the government notification dated 11/9/2019 and subsequent extension, have been selected as public prosecutors. So my submission here would be, Lordship, we have total advertised post was notified post was about 299. And in the select list, 241. Still huge number of vacancies are there, number one. And why there is huge number of vacancies? Because in spite of our best approach also, we could not get sufficient number of candidates who actually qualify or are skilled enough to take up these responsibilities. So whatever they are raising, those will have nothing to stand, because in spite of our best effort, we could not find 299 persons who are skilled enough to join in the service of the Assam of the prosecution under the Director of Prosecution in different 3 categories of post. So if at all Lordship wants to hear us on every factual aspects, Lordship will kindly give us 2 weeks time or 3 weeks time. We'll file the affidavit, bringing everything on record, because we have to look into the records which were under extreme custody of the 3 selection boards headed by 3 retired High Court judges. And there is no scope that they will be deprived, because they are still serving as public prosecutors, these writ petitioners in various categories, and we are not going to remove them immediately. They will be in service.
You're public prosecutors.
Additional public prosecutor. So in spite of their experience also, they did not qualify. That means there is some acute shortfall in their skill level. And the officers were not in the selection board. It is the honorable judges of the High Court. So we want very qualified and very technically skilled person with experience to join this service, because we want to revamp our whole prosecution spectrum of the state because of less number of conviction. And this
Mr.
whoever will be
On a
appointed now.
Lighter note,
Yes, Lord.
Mr. Advocate General. A judge may be good in while judging or sitting out here in the chair, but may not be so good downstairs
But
on the
at least
administrative side.
I do not like to pass any comments.
I will say, because
on
no,
lighter
just for
vein also.
example, this is a credit which I'll give it to you. These were the draft rules of the district draft rules which were being prepared.
Lordship.
These were being prepared all along by 5 judges of the High Court, properly making it, and then even the finance approved it. Then the legislative department caught hold of it. No, there are a lot of mistakes. Now they have drafted it properly.
Yes. That lady came to.
Yes, they drafted it
Yes.
properly. So therefore, putting much emphasis on a judge's interview or judges making all these things may not be proper. But anyway, that
But
is a
still,
different point of view.
we have to respect the system, Lordship, and we have to respect the experience of the honorable judges, because they have seen, and the judges who were there, they were also
But
practicing lawyers.
Mr. Advocate General, this is on a lighter note.
I understand, Lord. But still, I will not make any further comment, because it's in the lighter vein also, I cannot.
But we judges have realized one thing: the drafting is not our cup of tea.
Lordship.
It is absolutely
Interpretation
within
of
the
the-
domain of the
Yes,
legislative
Lordship. I
department.
fully agree,
Mr. Chaudhary, it is on the face of it. And it was I tell you, this is from 2018 it is being drafted. After drafting, going on, then we were putting in, then the Advocate General appeared, he said that there is a problem.
Instead of consolidating the rule, time to time, some administrative committee decisions are governing
Yeah.
the condition of service. That's why, my lord, we have so many litigations against.
Yes, Now, therefore I say that it is the best persons would be those persons who are there. Although I'm not saying anything on this matter, but we have realized that we have also certain follies, shortcomings.
So that is why Lordship is sufficient, a huge, several months were required to interview each and every one. It is not that
No.
overnight we have done
No.
it.
Mr. Advocate General, we'll do one thing. We need to finish up this matter as early as possible.
Yes.
Taking
No
into
difficulty.
account, you
That's
see,
why I'm saying only 2
taking
weeks.
into
time.
account this public prosecutor thing, because I'm going to put it subject to the outcome.
Yes.
No
So
difficulty.
therefore, this matter needs to be cleared of the air and all, whatever
Absolutely,
may be,
Lordship.
and whatever may be, this has to be done. We like to finish it off on 7th of March.
I put-
And therefore, you file your reply by 25th of February.
Before that, I will file.
No. For
Yes.
me to give it to you is this, 25th of
Because
February.
why I am saying Lordship,
And let them file their reply by 5th of March. 7th
Exactly.
is a Saturday, we take it up and finish it up.
Saturday Lordship would kindly not take.
No. 7th.
The Saturday Lordship, there is some difficulty on my part. Could it be on Monday
Monday,
or
no.
any other Saturday other than 7th?
Other Saturdays are all closed.
Yes. We'll have a relook in the matter.
Okay,
Yes,
then we do it on 5th.
5th, no difficulty. Why I'm saying Lordship? Because I have some other assignment on 7th,
Fifth.
irrespective of the day.
5th.
I
Then you have to file, as you say that you will file early, then by 20th of 20 February, you file
20
your
will
reply,
file.
and let them file their reply by 2nd.
Next 7 days we'll file.
7th. By 27th, you file your reply and we finish it off. Issue notice making it returnable on 5th of March 2026 at 2 p.m. How are you going to serve these people?
That is one problem, Miller. To this Home Secretary can serve it or Miller substitute can serve it.
Lordship would not burden us with that.
Well, we'll come up with an advertisement in the newspaper. Even that is very costly.
No, that is again problem.
We have the whole,
We don't even have the addresses also.
all addresses are there, Lordship, in the writ petition itself.
Or to the office of the Director of Prosecution.
Let it be served through the Deputy Secretary to the Government of Assam Home and Political Department.
Lordship, it will be difficult one, but
Why? These are all selected by you.
selected by you, Lordship, but that will create a huge problem for us.
Why?
That is a pure administrative work. It is not required to us. Had it been case of few small persons, Lordship, then we could have
These
done.
are all your employees. They are all selected.
They are yet to be employed.
No, they are to be
We are going to
selected.
issue the appointment order on 11th of this month.
Oh,
and
along
giving-
with that,
And we'll give them the opportunity to join after 15 days.
okay, along with that, give the certified copy,
No,
the petition copy.
Let them issue a paper publication. Had it
All
been,
the
had
all
it
the
been a
candidates
case of
have been
teachers, I
asked
would
to
have said
come
yes.
Report before the Deputy Secretary on February. Miller. That copy. Miller. On that day, they can do it.
Lordship will register my objection to this, that serving. Then Lordship may pass order, but I am
No, but
objecting.
Mr. Advocate General, this matter needs to
Other
you
things,
see,
Lordship, we
there's
are
a
always
problem.
cooperating, Lordship. If
You see,
someone
why
wants
do
to
you
solve the
put your-
recruitment process,
A cloud on this for this long time. You have a good.
Now, had
thing,
it been
but
case of
no,
Lordship,
because
any
why
other-
do you put a cloud on this? Because these public prosecutors are there, they are there, let him be work and do it without any fear and favor.
we are agreeing to everything, Lordship. In this case, they want to stall the this whole process of appointment. They participated, they failed. We do not have sympathy for this kind of writ petitioners. It is as simple as that.
Mr. Advocate General, do you think that this court has a sympathy for them? No. The only thing which this court is aware is,
Because we have,
there's a big problem. If these public prosecutors are not being given the jobs and all, the efficiency in which the BNS or BNSS is to be now, the criminal prosecution is to be regulated, would be stalled. So therefore, on the administrative side also, we want that these matters should be, there should not be any problem in this process. So as soon as possible, this cloud is being removed, it is much better for you as well as those public
or at
prosecutors
this
who
stage,
don't
Lordship
do.
may not issue the notice to the petitioners
No,
or the respondent.
No, I'll
Let the
issue-
issue notice be issued to us on the point of maintainability, the delay and latches.
That is too short, smaller point. Or that is too smaller point on the alien.
Then I have the right to argue
That
on
too
my
I can
point.
decide now only. That too I can decide now only on delay
That
and
for that
latches.
notice has to issue, we will file an affidavit. That is a factual decision Lordship will have to take.
On delay and latches.
No, on the point of delay and latches.
No. That will decide
That is
it
a-
now itself. But the others, if you don't help this court, there is no problem with that. But this is will be always a cloud hanging. That is at your lookout. But we at
Man,
the
Lordship, what
one
Lordship may pass a direction that
these
the director of
officers-
prosecution.
These officers who are there will be now being given an appointment out there. They should work without a fear that there is a case hanging on their head. That is why. Whether they get it or not, that's a different thing. That is why I want the matter
That
to be
they
done
will protect their
urgently.
job.
Hmm?
They will have to argue their case. I am not going to argue their case. I will argue only the case, how our selection board has proceeded with the whole interview process and whether they have done a transparent, fair and equitable manner they have done the selection. That is what I am going to defend. Regarding the eligibility,
Issue notice.
regarding their
Issue-
affidavit, all
issue
those are
not-
factual things they will have to argue.
Okay, issue notice making it returnable on 5th of May 2026. Mr. D. Nath accepts notice on behalf of the respondent numbers 1 to 5, 1 to 6. Extra copies of the writ petition be served upon him by tomorrow,
5th of March, Lordship, not
5th of May.
of May.
This matter won't finish, I tell you. And I'm putting it the reason why. 1 to 7, huh? Gusto. As regards the respondent number 8 to 252, the petitioner is directed to take steps by way of speed post within 7 days. In addition to that, the petitioners are also granted the liberty to take steps by way of trustee routed to the registry of the court and file an affidavit of service on or before the next date. I'm giving a liberty, not a direction. Gusto. The petitioners herein are aggrieved in the manner in which the selection to the post of public prosecutor, additional public prosecutor, and assistant public prosecutor were conducted. Mr. K. N. Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submits that without prejudice to the petitioner's right to challenge the rules, challenge the Assam State Prosecution Service Rules 2023. The manner in which the selection was conducted is contrary to the law laid down by the Supreme Court in various judgments. The learned counsel referred to the advertisement dated 2/1/2024. The learned senior counsel submitted that the advertisement as well as the call letter have been tailor-made in such a manner that contemporaneous records cannot be maintained. The learned senior counsel submitted that the perusal of the advertisement, there is no mention as regards what are the qualifications pertaining to the practice of the candidates before the criminal courts. And if that was the mandate and such application forms were required to and contain such documents which would show the skills of the persons of the candidates, then contemporaneous records could have been maintained. The learned senior counsel further submitted, drawing the attention of this court to the call letter, and more particularly to clauses 5 and 6, which requires the candidate to produce before the selection board at least one copy of the application appeal petition, etc., drafted by the candidate himself and filed in a court of law in any criminal proceedings, as well as also 4 copies of order judgments passed by a court of law in any criminal proceedings in which the candidate himself, herself appeared, conducted and argued the case. The learned senior counsel submitted, if these were the requirements to be placed only before the selection board, the question of maintaining contemporaneous records does not arise. Under no circumstances, it is as submitted by the learned counsel appearing on behalf of the senior counsel appearing on behalf of the petitioner. A conjoint reading of the advertisement read with the call letter would show that the selection was conducted in a manner in terms with Article 14 of the Constitution. The learned senior counsel further referring to the rules of 2023 drew the attention of this court to Rule 19.2. The learned senior counsel submits that the said Rule 19 Roman 2 is in conflict with the well-settled principles laid down by the Supreme Court, that there cannot be 100% marks allotted for interview. Be that as it may, the learned senior counsel submits that the petitioner reserves the right to challenge the Rule 19.2. He further submits that even as per Rule 19.2, there is nothing mention as to how the proficiency cum skill test was applied. For assessing the candidates as per the parameters laid therein. Anything else? That's all. Per contra, the learned Advocate General who appeared on behalf of the respondent numbers 1 to 7 submitted that the interview was, that the advertisement, that the rules were notified on 7/12/2023. The petitioners knew about these rules, and more particularly to Rule 19.2 of the Rules of 2023. The Learned Advocate General further submitted that the advertisement was issued on 2/1/2024. And the petitioners knew very well as regards the contents of the said advertisement. Further, the Learned Advocate General also referred to the call letters which were issued sometime in the month of October 2024. And the petitioners knew the contents thereof. The Learned Advocate General therefore submits that this is a case where the petitioners, after having applied and becoming unsuccessful, is now trying to challenge the process. In addition to that, the Learned Advocate General also submitted that this is a case which suffers from gross delay and laches, inasmuch as the petitioners knew about the rules which was notified on 7/12/2023, as well as the advertisement dated 2/1/2024. Full. The Learned Advocate General therefore submitted that this is a classic case wherein the instant writ petition ought to be dismissed on the ground of maintainability, taking into account the judgment of the Supreme Court in the case of State of J&K versus Madan Lal, reported in AIR 1995 SC so and so. Full stop. In addition to that, the Learned Advocate General submitted that there was no infirmity in the selection. The selection was carried out by a selection panel consisting of judges of the High Court. And the selection was carried out for a continuous period of 6 months, and thereupon the select list, the provisional select list, was published.
More than 6 months, Lordship.
More than 6 months. Full stop. Anything else?
Their prayer that there is no prayer for stay of the process. I have repeated their submission that they have made a specific submission that they are not praying for any stay of the recruitment process. I am reiterated that.
That is his submission.
Yeah, I reiterated that. I highlighted that.
Per contra, Mr. K. N. Chaudhary, the Learned Counsel, Senior Counsel, appearing on behalf of the petitioner, submits, drawing attention to clause 8, Roman 4 of the advertisement, which stipulates that a self-declaration has to be given that the candidate has not left practice as an advocate and has not joined any other service or profession or business. In that regard, the Learned Senior Counsel referred to paragraph number 13
22.
22 of the writ petition and gave instances wherein certain selected candidates who left the profession, the profession of advocacy and joined as members of the Foreigners Tribunal. The Learned Senior Council submitted that if this selection process was conducted in such a manner, and without taking into account these aspects and the persons whose names have been mentioned in paragraph number 22 have been included, the said selection process under no circumstances can be said to be done in a proper manner. So in that regard, the Learned Senior Council has also referred to the judgment of the Supreme Court. এইটো নজৰুল ইছলামৰ জাজমেণ্টটো আছে নে? সেইদিনা যে মই ওলাইছিলো ষ্টেনোগ্ৰাফাৰৰ জাজমেণ্টটো, তাত এটা জাজমেণ্ট এটা আছে, তাৰ ভিতৰত এটা আছে. Had referred to the judgment of the Supreme Court in the case of so-and-so and submitted that it is only upon participation in the said selection process the petitioner can challenge. The Learned Senior Councils, however, with fairness, submitted that the petitioners would not ask for an interim order at this stage, but any appointments so made on the basis of the select list which has been impugned in the instant proceeding should be made subject to the outcome of the writ petition. This court have duly taken note of the above submissions. It is the opinion of this court that the respondents should be given an opportunity to file their affidavit in opposition. Accordingly, liberty is given to the respondents to bring on record their stand by filing their affidavits. The affidavits be filed on or before 2026. Liberty given to the petitioners to file their replies. Records be kept. An attempt shall be made to dispose of the writ petition on the next date. The state is directed to produce the records of the selection proceedings, and more particularly in respect to the allegations so made by the petitioners on the next date. Any appointment made on the basis of the select list shall be subject to the outcome of the writ petitions.
7th of May.
5th.
5th of deeply.
Then on page 25, my lord.
So this was corrected, page 25.
No,
Written to the AR that his date of birth, as per the government letter, he joined as a MR labor on 1/2/193 and regularized on so-and-so. And his date of birth is, retirement is here, but as per school certificate, PAN card, Aadhaar card, etc., his date of birth is 1/12/1973. Hence, his date of retirement becomes 30/11/23. Request to kindly look into them. With reference to the letter dated Iman, undersigned has called on to more clarity in the matter of the date of birth in respect of Iman under the division. Therefore, you are directed to submit a report citing the genuineness of the school certificate, so and so Iman. Then,
my lord.
when executive
27,
Sarnia says that Iman is Iman, hence his date of retirement, the chief engineer so and so had directed to report it. So you kindly confirm the genuineness of ER. Then he writes to the deputy commissioner. Then superannuation notice. So this aspect, as regards the verification, is going on. Now, while this verification is going on,
If you know better.
the executive engineer, he has issued the superannuation notice as per your date of retirement. You are otherwise to retire on 31/3.
Not-
You have time.
not-
Chalo. We have to look into as early as possible. Have you made the school certificate is given by whom?
Yes, madam.
Huh? '92.
Yes, 70.
How did your date of birth become 31/3? Mr. Nayak, tell me why this seems to be an overriding or strike off at page 21?
Page 31.
21.
Lordship, may kindly say page 21.
That is what
Lordship,
I'm saying.
this, initially it was written as 31/3/66.
Ah,
Against that date, Lordship, it is
Ah.
written as per school certificate.
ah,
Now, this service book was prepared in the year 2006 itself. Lordship, you
Ah.
see down below. And if Lordship comes to the second line, Anwar Hussain, Assamese Muslim, and the A mentioned is as per school certificate. Both the A's are similar. So this as per school certificate, it relates to 31/3/1966, not to 01/12/1973. And secondly, Lordship, if somebody corrects the dates in the service book, Lordship, a signature should have been there.
that is why I'm saying.
So my understanding, Lordship, in the regularization order, the date was inserted on the basis of some school certificate, and according to which his date of retirement was calculated as 2060, 20, I mean,
You
60.
just find out that aspect and bring it on affidavit.
Now, what records are available in the office that I
No,
have
no.
seen, Lordship? But
You
my-
may find out at
Lordship.
the time of regularization, what is the document given? Because that would be the document.
Yes.
Because it is next to impossible. I would have understood a matriculation certificate may be there, but this is not. He has not passed class 4.
But second aspect is there, Lordship,
Ah.
page 24, this is
Hmm.
vernacular.
Hmm.
Lordship, he made an application for correction of date, Lordship, only on 2011/2025. That is just prior to his retirement, Lordship. And if, as per the FRSR, Lordship.
No,
he
no,
could have
no. He
applied.
need not ask for correction because the service book has corrected. See, the problem is not there because the service book is corrected.
No,
So
cor-
he now says that as per the service book, I should retire in 2033.
No, whether this correction.
So
will be
therefore, the question
accepted or
is,
not,
you need to inquire
Lordship.
as to why there is a change in the service book later on.
Yes.
That is the question which needs to be looked into. Because when he joined, you see, he was confirmed in the year 2005,
Regularize
regularized. So his service book will be then prepared then,
in 2006 itself,
2006.
Lordship.
So his service book was prepared.
Lordship.
So therefore, if there is a striking off,
Somebody, Lordship, who did this, Lordship, that is also not.
why it is being struck off?
Who's,
But the handwriting seems to same.
no.
Anyway, you
Handwriting,
can just
original
find
handwriting.
out why there is no the overwritten. Anyway, issue notice making it returnable on 27/2/2026. Mr. Inayak accepts notice on behalf of the respondent numbers 1,
1,
2,
2, and
3,
3, Lordship.
and Mr. Debora accepts notice on behalf of the respondent number 4. The grievance of the petitioner herein is that the respondent number 3 have issued a communication, a superannuation notice that the petitioner would retire with effect from 31/3/2026. It is the case of the petitioner that the petitioner's date of birth is 1/12/1973, which date of birth is also reflected in the PAN card, Aadhaar card, etc. However, at the time of regularization of the petitioner, the date of the petitioner's, the date of birth of the petitioner, the date of retirement of the petitioner was put as 31/3/2026. And it is on the basis thereof, this superannuation notice has been issued. It is the case, further case of the petitioner that the petitioner on coming to learn about the said aspect had submitted a representation on 25/11/2025 for making necessary correction in as much as in the service book it is written as in the service and in as much as per the service book, the date of the retirement of the petitioner is 30/11/2033. Full stop. An enquiry process is going on, but in the midst of that, the impugned superannuation notice have been issued. It is under such circumstances the petitioner is before this court. The respondents are directed to make an inquiry as to is directed to carry out the inquiry on the basis of contemporaneous records as to what would be the date of the birth, why the date of birth of the petitioner in the as per in his regularization order has been put. Why the date of retirement in the regularization order has been put as 31/3/2026. Further to that, the respondent shall also make an inquiry why in the service book the date of birth date of birth being 31/3/66 was struck off and subsequently 1/12/1973 was inserted. An affidavit in that regard be filed on or before 23rd of February 2026. Full stop. The matter requires an urgent disposal taking into account that the petitioner is otherwise going to retire on 31/3/2026. Under such circumstances, the respondents are therefore directed to file the affidavit on or before the date fixed herein above without fail.
That is alone. Herein his candidature was rejected for height. And at the instance of PST alone.
When was it rejected?
22/8/2000.
Why you are approaching today? How can I allow you? The appeal is to be filed within the next date, on that day. Did you ask for the appeal?
There is no provision of appeal, Lordship.
No, there is a provision of.
PST, Lordship. It was PST.
No, there is an appeal.
Yes.
There is a provision of appeal. So the appeal is to be filed and in fact his rejection order also says so. Kindly see, page 45.
29.
Lordship.
So if this appeal was filed on that day, then
That day, your lordship, the rejection slip was sent over at evening 7 PM, your lordship. But the next day, the petitioner approached before them, but they.
where is that you have approached? Where is it that you have approached?
Para 7 of my petition.
And then, okay, thereafter, why you are coming after such a long time?
Para 8, your lordship, I have made a statement, your lordship. Why
Then
they-
what happened?
Because
You became shorter.
petitioner, someone was engaged by the petitioner, your lordship, to file case.
Huh?
Someone was engaged by the petitioner to file a case.
No. This is not a
He-
case where I'm going to exercise.
In the month of January, he returned back the brief, your lordship.
Whom? Who is the person whom he has asked? Who was engaged?
Para 8 of my petition, I have.
He was engaged whom?
He is one of the relative of the
For
petitioner.
filing appeal, but it was not entertained. Thereafter, the petitioner handed over the details relevant to a person for engaging the advocate. Advocate is also not known. That person you don't know. That person came to you.
One relative, your lordship, he is one of the.
Don't come up with this unless you take
Immediately,
any
sir,
action.
immediately,
No. No,
That delay, your lordship, is,
no, you have approached this court in so late. This is
I
going.
admit, your lordship, that. That part, your lordship, I admit, your lordship.
Because the judgment which has been referred to out here cannot be applied to the facts of the case. And more particularly, that order was a consensus order by Mr. B. Chakraborty in that matter, isn't it?
Lordship.
Yeah.
And moreover,
But
Lordship,
how
the
can we permit now?
select lists also published, Lordship.
Select list published, then
Published.
can't help it. And how does the medical college say that you are hired is 165?
He was majority, your lordship.
Why the medical college? And why did you approach? Now tell me one thing, very interesting, another thing. Another thing. So you went on to the medical college on the next day.
Next day.
You went to the medical college on air and they found it 165. Is the medical college the fit to decide what is the height? Is it, Mr. Dhar? You are women empowerment department. Is it fit? Medical college? Social justice. You are the best person to answer. Is the medical college fit to decide what is the height? The medical board did not look into the height. It was another board. They looked into the height and found 163.8. The next day he became taller by more than 1 inch. I'm not going to do that. And you have approached this in the month of January. Sorry. No. Can't help it. If I ask you to file an appeal, everybody will come.
Lordship. Lordship.
But in fact, your lordship, on the next day, the petitioner went there, but his appeal was not admitted.
So did you write a letter representation? Where is the representation?
So that has not been accepted by them, your lordship.
Where is it that it was not accepted?
It's para 8, your lordship.
I've
but
read it.
Was not entertained.
Authority for filing appeal, but it was not entertained.
Then they won, lordship, that is not possible because it was handed over at 7 PM. But the next day, they refused to accept it.
Next day you went there for an appeal. Then
It was not entertained.
you went to the medical college.
Yes.
Yes.
You went to the
Thereafter,
medical college.
The petitioner engaged someone, that is one of his relatives. He was authorized to file this instant petition, but in the month of.
Medical
January-
college nowadays have started looking for height also. Social justice.
Health department.
No case. Sorry. Heard Mr. A.M. Khan, the learned counsel appearing on behalf of the petitioner. Mr. S.S. Roy, the learned counsel who appears on behalf of
All the,
the respondent numbers.
all the respond.
All the respondents. The petitioner herein is aggrieved by the rejection of the petitioner's candidature in the PST examination on the ground that the petitioner's height was found at 163.5.
8.
Height?
163.8.
163.8. And the minimum height should have been 165 cm. So the petitioner thereupon, it is alleged by the petitioner that on the next day, the petitioner went to submit an appeal which was not entertained. Thereupon, the petitioner got himself measured in the Dhubri Medical College on 28/8/2025. And it was measured and the height of the petitioner was found to be 165 cm. So it is under such circumstances the petitioner has approached this court by filing the present writ petition on 27/1/2026. This court inquired with the learned counsel appearing on behalf of the petitioner as to why the petitioner has approached this court so late, more particularly after a passage of more than 5 months, 3, 4, 5 months, Full stop. The learned counsel submitted that the petitioner had engaged some person to have asked some person to file some person to engage an advocate to file a case. And it was only in the month of January 2026 the petitioner came to learn that no case was filed. Full stop. In the opinion of this court, the said explanation which is given at paragraph number 8 does not appear to be convincing. Rather, it appears to be an afterthought, more particularly when the material facts are more particularly when such vague material facts have been mentioned. Considering the above, this court does not find the present case to be a fit case to be entertained. Accordingly, the petition stands dismissed. line Mr. S.S. Roy also submits that in the meantime, the provisional select list has also been published. Mr. B. Chakravarti, you have seen my order? That case?
Today I have just got it downloaded, madam.
I did one thing. Certain things I can't touch it, but as regards whether 15,447 metric tons was done through this TT enterprise and all, I said that this particular thing I can't look into it. So I even said that therefore I cannot decide as regards the legality and value by allowing you to go to the civil court, and further also gave you that these observations shall not affect and also the limitation.
But I've seen that right now, madam.
I gave you the limitation also because this aspect, you had a case, but this case is only to be looked only in that angle.
I have retired from service on 31st May 2025 as UDA, madam. But I am not in a position to submit my action paper as for the.
Yes, no departmental proceedings.
No proceeding, nothing.
And then because of the suspension has been put as a gap period.
Yeah, period, and they fixed this pay in a peculiar manner, that has not been regularized. So I cannot submit my pension paper. So,
Accountant General is a party, yeah?
he is the party.
Issue notice making it returnable on 6th of March 2026. Child welfare. You are there. Ms. M. Bhattacharjee accepts notice on behalf of the respondent numbers 1, 2, and 3. And Mr. C. Borwa accepts notice on behalf of the respondent number 4. The grievance of the petitioner herein is that the petitioner was appointed as a driver in the year 1984, and subsequently he was promoted to the post of LDA and thereafter UDA. So while serving as an LDA, the petitioner was placed under suspension with effect from 19/1/1995. His suspension continued for a period of 15 years and there was no departmental proceedings. Subsequently, on repeated request, the petitioner was reinstated on 19/2/2010. In the meantime, the petitioner have retired on 31/5/2025. The respondent, it is the case of the petitioner that on one hand, the respondent authorities kept the petitioner under suspension for no good reason, that too even without initiating departmental proceedings. And because of that, the petitioner is not in a position to submit the pension papers, more particularly taking into account that said gap period. So under such circumstances, the petitioner therefore has approached this court. The respondents herein are directed to file their affidavits on or before 2nd of March 2026. In the said affidavit, the respondents have to categorically mention is asked to the respondents are directed to stipulate, mention as to why the period from 1995 to 2010, wherein the petitioner was kept under suspension without a departmental proceedings have not been regularized. List according.
There's an increase there regarding provisional pension. In any case, I am entitled for that, madam.
See,
All right.
another line like taking into account that the petitioner as on date have not even received the provisional pension, comma, the respondents are directed to file their affidavits without fail as on the date so fixed herein above.
All right.
An attempt shall be made to dispose of the petition on the next. Yes, what is this?
Petitioner and the respondent number 4
Hmm.
participate in the selection process for appointment of Rao Prabha Mata. Respondent number 4 was selected, pursuant to which, my lord, the petitioner preferred a petition before this honorable court. My lord, we kindly come to page 14, my lord. This is an order, sir, dated 22/3/2023.
You filed an appeal, then
Yes, my lord. The appeal was filed and subsequently, my lord,
where is the order in the appeal?
starts at page 38. The relevant portion, my lord, is at page 42. The last paragraph, my lord, the third paragraph. The
The
margins-
allocation of 15 out of 30 marks for relative iman to the applicant without that violates the iman of the iman. The marginal marks of 31 for the respondent of 4 is students. No, the law quality the population of this state is with qualifications. Eventually. Then
The selection goes, so I ought to have been made, I ought to have been appointed, my lord.
why?
I was the applicant, my lord. I was the.
So election goes fresh selection.
No, my lord,
Yes, fresh selection.
there's a list, select list, my lord.
How can I direct to appoint you?
My lord, what had happened, my lord? What
Where
is?
is it the rule that if there are two persons are there,
My
if
lord.
there is a selection conducted, one person is selected, the other person is not,
Yes.
then that person challenges that appeal.
My lord.
The appeal categorically says that his selection is bad. Then how can I direct that you appoint him?
My lord, the case here, my lord, subject. to-
You want me to become the director of land records?
Absolutely not, my lord.
Well-
In fact, director of land records.
Director of
has
land records.
determined, my lord, the director of.
What do you say, Mr. Doctor? That they also have passed one order. Yes, in that case. There will be a fresh election.
My lord.
Participate. As per,
In fact, what has happened?
we can very well say
My lord.
that the director of land records was therefore required after setting aside the selection to pass further year for selection of a fresh candidate. And as such, having not done so, this court directs the respondents to take appropriate steps. You want that?
No, because your lordship is very right. In fact, when the appointment is done, the appointment.
I would have understood if the appellate authority would have said,
That is what we want. Ensure by way of this petition. my
no,
lord.
I cannot.
My-
I
my-
cannot, because of the fact that I cannot, the appellate authority would have said that, look here, because you see, appeal is different
My lord.
from what am I? I am to look into as to whether it is right or wrong. So therefore, it is for the appellate authority to, why you are not filing a review before the state government?
My lord, the review ought to have been filed by the private respondent who's a.
You file that review if you want.
If need, my lord, I'm happy with the order. My lord, that is my submission. In fact, the selection is made out of a comparative.
Oh, if
state.
you want that, you go for fresh selection. I can't help it.
If that is directed, my lord, I'll be grateful, my lord.
Mr. Datta, I think we can, that once it is being set aside, there's a a new process has to be initiated. So you should take steps.
Recently, your lordship has passed an order in fact in.
That day I passed one where I dismissed one
Lordship,
case.
Lordship.
There was, he got a stay out there.
Lordship.
Ah. Yes, yes. heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. S. Dutta, who appears on behalf of the Revenue Department of the Government of Assam, and Miss M. Bhattacharjee, who appears on behalf of the respondents, number 2 and 3.
Three I'm appearing,
2.
only two.
2. Full stop. Taking into account the order which this court proposes to pass, comma, the service upon the notice upon the respondent number 4 is dispensed with. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not appointing the petitioner as the Gao Pradhan pursuant to the setting aside of the selection of the performer respondent number 4 as the Gao Pradhan. It is under such circumstances the present petition has been filed. This court have duly perused the materials on record. From a perusal of the materials on record, it is apparent that the performer respondent number 4 was selected as the Gao Pradhan in respect to
Lot number 1.
lot number 1 of Sutorgao Muramari Pam in Dhing Moza under Dhing Revenue Circle. Full stop. The petitioner thereupon challenged the said selection of the performer respondent number 4 before this court, which was registered by way of a writ petition, which was registered and numbered as WPC number 1587/2023. Full stop. This court did not enter into the said dispute and gave liberty to the petitioner to file an appeal in terms with Executive Instruction number 162(c) of the Assam Land and Revenue Regulation 1886. Pursuant thereto, on the basis of the said leave, the petitioner thereupon preferred an appeal which was registered and numbered as RR(CAD) 11/2023. Full stop. The Director of Land Records, by the speaking order dated 26/9/2025, held that the selection of the performer respondent number 4 was in violation to the executive instructions and more particularly clause 162 Roman 5 and accordingly set aside the selection of the performer respondent number 4 as the Gao Pradhan of lot number 1 Sutorgao Muramari Pam. Full stop. The grievance of the petitioner is that pursuant thereto, the Director of Land Records and Survey Assam should have directed the concerned authorities to appoint the petitioner as the Gao Pradhan of lot number 1 Sutorgao Muramari Pam village. Full stop. And in that regard had submitted representation which, not being considered, the present petition has been filed. Full stop. This court have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. It is the opinion of this court that upon setting aside the appointment of the respondent, setting aside the appointment of the performer respondent number 4 as the Gao Pradhan, comma, the non-exercise of the jurisdiction by the appellate authority to direct the concerned authorities to appoint the petitioner as the Gao Pradhan do not call for any interference, taking into account that the Director of Land Records and Survey, that is the respondent number 3, have only decided as regards the legality and validity of the selection process. Full stop. This court further, in exercise of the writ jurisdiction, cannot direct the respondent authorities to appoint the petitioner as the Gao Pradhan. Full stop. Under such circumstances, this court does not find any merit in the instant writ petition for which the writ petition stands dismissed. Before parting with the record, this court, however, observes that taking into account that the selection to the post of Gaon Pradhan in a village con have been set aside, the respondent authorities are it would be the requirement of law that the respondent authorities fills up the post by following the due process.
Apply.
Mr. A.M. Khan, you and 5/9/2024 have been, what will happen after 5/9/2024 is gone? I only see you with 5/9/2024. In fact, they caught the wrong person. To dispose of. Knock me. Hey, tar namor je eta judgment ase. File when.
What's the visit page 38, para 6.
Final list published.
Well, yes,
Yes. Where is that?
page 31. Page 31, madam. In page 32, the two posts are concerned posts are mentioned. One is technician assistant for CSS, another is technician for CSS.
The petitioner, one petitioner,
Yes.
he participated in both the posts.
My lord, he participated for both, but my lord, he could not qualify in the written test itself.
Whatever my challenge is that, what the list 31 is still supposed that in that list is not the merit list, my lord. That is not merit list. This is not the final list. This is the provisional list, my lord. It is clearly stated that it is for the information of all concerned that the candidates being the following rule numbers are the provisionally selected for a various grade 3 technical post under the Director of Medical Education. And so and so, so and so, so and so. And my lord, on the basis of that, my lord, that selection here, and in my post, technician assistant for CSS, 9 person has been selected out of 48, out of 55, and technician for the CSS, 33 person has been selected for a finally appointed. Well, this is not the merit list, my lord. In this regard, at the time of the issuance of the notice, motion is list, my lord, I have submitted that they are going to make the appointment on the basis of that provisional select list without publishing any merit list, my lord. In this regard, I have submitted an observation made by the Honorable Supreme Court, my lord. In that observation, my lord, Supreme Court observed that without the merit list, on the basis of the provisional list or any other list, my lord, selected candidate cannot be appointed. This is there, my lord. Very small. That another. Paragraph 4 also.
List and yes. Entire compilation plus two. Plus two.
Hmm.
Plus two. Plus two.
Mr. Burua, how does this judgment apply to you?
Another thing is that, my lord, they had advertised for a post of 55. They have selected only 9.
Huh?
They have advertised for a post which I have appeared, my lord.
You applied for which one?
2 posts, my lord. That is lodgeable files.
You applied for technician for CSS.
And,
Huh?
yes, my lord. Technician assistant for CSS and technician. for
Admit
CSS.
card, Annexure 3.
That's the page 24. Lord.
Annexure 3.
That's a 2, my lord. Page 24, my lord.
Annexure 3 is technician for CSS.
Second, the technician for CSS.
One admit card you have enclosed.
See?
Annexure 3 is the admit card
Admit
for technician for CSS, comma, technician assistant for CSS. Okay. Then
There are 2 posts, my lord. Lodging at page 24 for technician assistant for CSS 55. That's page serial number 48.
technician in the advertisement, where is that?
That is the advertisement, my lord.
Hmm.
That's a 2.
Technician. Technician, where? Technician for CSS. Where do you say 55? Oh, here.
48,
Page 20,
24, my lord.
48, 55 posts,
55, technician
48 and 50. 48 and 50. So 50, 48 has 55 posts.
Yeah.
So they have only selected 1, 2, 3, 4, 5, 6, 7, 8, 9.
9.
And the other is 48. Out of 48, they have selected 1, 2, 3, 4, 5, 6, 7. 7 into 4, 28, 29. So 29 they have selected.
On 39.
So,
51.
so
And my what does my lord? Is it that my lord? There is not in that provisional select list, my lord.
this is not provisional select. This is the select list itself. So they have been provisionally selected and the appointment letters will be issued. There are many other things which
Yes,
looks to
police
be used.
verification and all is there.
Re-verification, all these things will happen. No case. Oh, yeah, that is over. This is to inform the following who have been provisionally selected under PWD for different so and so are directed to appear before the medical board. This is for PWD. You are PWD? No. Why Annexure 7 has been included?
That, my lord, subject to verification. Subject to medical verification, they have been confirmed in page 34.
That has been also
And
published.
petitioner does not belong to this category. Not on the same case.
These are all PWD for various posts.
Yes.
This is not for any, for different grade 3. So for everybody, there are how many posts for PWD? PWD.
That is not bad from my, that is. Simply mention that the.
PWD, there will be posts now, they have to mention, anyway, that is not your lookout.
That is for the women, the person stability will be as per the prevailing government rules. Then I have clear.
Mr. Gugoi, kindly come to page 24.
Yes, serial 48 and 50, madam.
48 shows unreserved post is 27. Kindly come to page 38. Why only 25 posts has been mentioned?
My lord, page
38.
or 30. Lordship will say 39, madam. You have given the chart.
I've seen 38. Unreserved post 25, why is it mentioned? Means on the other hand, in the advertisement, it is shown as
Technician.
27.
Yes, ma'am. Technician is 25, madam.
Where 25?
Page
Or
24.
technician is
below.
25.
Yes.
11. SC no candidate. STP 3 as there were no candidate. Shortlisted, so you are general? Okay, so you shortlisted 78. You are shortlisted.
Shortlisted.
But they have therefore appointed how many?
In one.
For the first one is 9 and second was 33.
33.
So why you have not appointed everything?
My lord, here so far as my lord that part is concerned, I have inquired, my lord. Here, my lord, all the candidates, they appeared for both the posts, technician, assistant, as well as technician.
Hmm.
Now, my lord, majority who were, my lord, been selected for technician, which is the higher post, my lord, they were also selected for technician, assistant.
Hmm.
So being, my lord, first preference being, my lord, technician, they have been, my lord, selected in this particular post. And 9, my lord, left out who came within the zone of consideration where, my lord, appointed as
And the
technical.
petitioner did not qualify.
He did not qualify.
So there
Within
were
the zone.
therefore no candidates.
No candidates.
And appointments were made on 2020
Yes.
2025.
2012, 25.
Now, heard Mr. D. Woolworth, the learned counsel appearing on behalf of the petitioner. Mr. B. Gugoi, the learned standing counsel of the Health and Family Welfare Department of the Government of Assam, appears on behalf of the respondent numbers 1, 2, and 3. The petitioner herein has challenged the provisional select list dated 12/10/2025 insofar as the post of technician assistant for CSS and technician for CSS primarily on the ground that on the basis of a provisional select list, no person can be appointed. On the basis of a provisional select list, no person can be appointed. No person can be appointed. That is your contention. Basis of a provisional select list, no person can be appointed. In addition to that, the learned counsel appearing on behalf of the petitioner further submits that a perusal of the advertisement would reveal that in respect to the post of technician for CSS, 27 posts were kept for unreserved category. And in respect to technician for CSS, 25 posts were kept for unreserved category. The learned counsel appearing on behalf of the petitioner submits that although there were total 55 posts advertised for technician assistant for CSS and 48 posts for technician for SCSS, only 9 persons were provisionally selected for the post of technician assistant for CSS, and 29 persons were selected for provisionally selected for technician for CSS. He therefore submits that although various posts were, although the number of posts advertised was much higher, but the select list, provisional select list, contains fewer number of posts, and thereby the petitioner who was otherwise eligible have not been appointed, recommended and appointed. Full stop. In that regard, the learned counsel have also relied upon the judgment of the Supreme Court in the case of the state of Bihar versus Kaushal Kishore Singh and others, reported in 1997
1998 9 SCC 104.
AIR 1997 SC 2643. Full stop. It is seen that pursuant to the order passed by this court on 18/12/2025, an affidavit in opposition was filed by the respondent number 2, has been filed by the respondent number 2, wherein it was mentioned that the notice dated 11/11/2025 was published for verification of the benchmark disability, wherein it was mentioned that for the post of technician for CSS, wherein the total unreserved category posts were 25, 78 persons candidates were shortlisted. It included the petitioner. In respect to the technician assistant for CSS, wherein the unreserved post was 27, 81 candidates, including the petitioner, was shortlisted. This shortlisting of these candidates was for skill test and document verification. Upon carrying out the skill test and document verification, it was found that the petitioner was not eligible for appointment. It was further mentioned that the select list, that the notice dated 12/10/2025 is not a provisional select list, but a select list wherein indicating that the candidates have been provisionally selected subject to various other verifications. He therefore the Pustap. In the backdrop of the above, this court have also heard the learned counsels appearing on behalf of the parties. From the contentions which have been made by the learned counsel appearing on behalf of the parties, petitioner, as well as the materials on record, as well as the pleadings of the petitioner, it appears that the petitioner have assailed the notice dated 12/10/2025 on two grounds. First, the notice dated 12/10/2025 cannot be said to be a select list, and since a select list, no person can be appointed. Pustap. In that regard, reference was made to the judgment of the Supreme Court in the case of Kaushal Kishore Singh Supra. The second contention which have been raised is, although there were there were more posts, but only few number of posts were filled up by way of the advertisement, were filled up in the said selection process. In that regard, the learned counsel referred that for the post of that referred, while referring to the advertisement submitted, that for the post of technician assistant for CSS, wherein the petitioner had participated, out of the total number of 55 posts, only 9 persons were selected. And in respect to the post of technician for CSS, which were 48 posts, only 29 persons were selected. He therefore submitted, the learned counsel therefore submitted, that non-selecting the others without stipulating the benchmark as to how the petitioner was held to be not eligible, have also not been mentioned in the affidavit in opposition. A vague statement in that regard have been mentioned. So, taking into account the above, this court inquired with Mr. B. Gogoi, the learned standing counsel, who appears on behalf of the respondent numbers 1, 2, and 3, as to why as regards the benchmark on which the petitioner was found not eligible. The learned counsel, standing counsel, submitted that a further affidavit would be filed in that regard. List this matter again on 25th of February 2026. In the meantime, an affidavit providing the details as to on what basis only fewer posts have been selected and why the petitioner was found to be not eligible may be given in more detail. Liberty is also given to the petitioner to file any reply.
I have a small fear, my lord. 25, any date not on 25, my lord, 25, I will be busy with my son, my lord.
27.
Yes. The discussion to withdraw, my lord, just for challenging the, my lord, clause 6.5, my lord.
Oh. It's 6.5 or challenge those. Here, Patni.
Yeah.
Withdraw with liberty.
My lord. Okay.
You, Mr. Padgiri, yesterday there was, you have up for the better case.
Well.
Because your document, you got it on 27/3/2025.
During the financial year.
Not only financial year, within the period of 80 days, 180 days from 14/10 to 2024. There are two circulars. Yesterday, you asked Mr. M.K. Mishra. There, he ask him about this. So there is a judgment also of the Delhi High Court which went to the Supreme Court. The Supreme Court dismissed it. Take it up on that. Yes, what is this? Who is appearing for this?
But I'm a formal party. 1 and 2 is the main respondent, Warehouse Corporation.
This is a contempt.
Yes.
Isn't it a contempt? Why are you filing a writ?
My lord, already they have paid most of the amount. Most of the amount they have been paid. They admitted before the earlier question, my lord, they had admitted the fact that they will pay. Accordingly, they paid, my lord. Small amount of money had to be paid already transferred in that.
How much?
64,300.
Huh?
64,000
Left.
left, my lord. And 7% of the entire amount.
Where have you represented that you have not got the 64,000?
Yes, madam. Page 25.
Where?
Page 25 and it's at post.
Huh? This is 16 lakhs. Where is the 64,000?
No, 16,000 now. 16 lakh, 16,
Out of 16 lakhs, you have got some money.
yes, madam.
So remaining is 64,000. Where have you represented them? That remaining is there. There's a calculation mistake. You directly approach this court. Do you either way you file a contempt or not? Why should I interpret all these things? That case, go. Representation. No case. The heard Mr. Learned Counsel appearing on behalf of the petitioner and Miss M.D. Bora who appears on behalf of the Transport
Corporation Department.
Corporation Department of the
Responsible
Government of
matter.
Assam. The petitioner herein have assailed, the petitioner has filed the instant writ petition alleging that pursuant to the directions passed by this court in the order dated 22/2023 in WPC number 5088/2022. The petitioner has received the amounts as directed by this court, except an amount of rupees 64,371, which the respondents have not paid. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether the respondents were duly intimated that an amount of rupees 64,371 is still outstanding. The learned counsel submits that the petitioner would be well advised to file a representation before the concerned respondent authorities, bringing to their attention that out of the total amount, a further amount of rupees 64,371 is still pending. Full stop. Taking into account the above, this court therefore is not inclined to entertain the instant writ petition at this stage. Liberty given to the petitioner to submit a representation before the concerned respondent authorities, more particularly the respondent number 2, as claiming the further claiming that a further amount of rupees 64,371 along with interest is payable to the petitioner.
7% 7%.
Huh?
7%.
Along with the interest payable to the bank.
Observed by your lordship.
Full stop. In the circumstance, such representation is filed, comma, the responding authorities, more particularly the respondent number 2, shall duly consider the same and do the needful.
40
Liberty given to the petitioner to approach this court if within a reasonable period of time the said amount, if the petitioner is aggrieved by the non-consideration of the representation after a reasonable period of time.
obliged lordship. 14 is the similar. Amount is different.
Amount different.
Obliged.
Same order disposed. We dispose it of 10 days representation along with that, whatever it is to be given. Medical board, na?
Yes. Yes.
You-
Only thing they said that I have a dimple-like thing on my skin.
Understood.
I mean, it's not that I'm totally fit. I must be honest. They said I'm otherwise fit, but I have a dimple-like thing on my skin. Like we have a dimple in the.
Then you showed it to somebody and they said it is okay.
No, so first they said something on the nose. Then they went on, when I went to the medical college, they said, no, nothing doing. You only have a dimple-like thing on your skin. So what I say is that if they consider, in the meantime, in the interregnum, if they go ahead, and things are filled.
Therefore, my order is same. 10
Right.
days giving you time to submit representation along with those medical documents within 60 days to decide.
Right.
English Council.
What is this?
English Council is on leg.
Okay, this is the matter on Monday. Wednesday.
I don't take some. Just no, I don't. It's a
Yes, what is your case?
It's a covert method regarding payment of.
Who is paying for the respondents?
The irrigation department.
It's covered.
Covered. No.
Why is it covered?
And this is regarding payment of key components of garage benefits. It was allowed by this court by an order dated 13/5/22. You would find it at page 106.
Covered?
Lordship, in fact.
Covered by which order?
Page 106. It starts.
This order at 136 covered.
Yes, sir.
The lawyer also seems to be the same.
Lordship.
Huh?
Lordship. Therefore, other order.
Which order should I follow, Mr. Upadhyay? That is the limit. We follow the 24/7. What do you say?
Lordship, yes, Lord. Yes,
Huh?
Lordship.
24/7.
Lord,
It will be cover করে dispose of করে দিন। Dispose.
I'm for 3, 4, and 5, Lordship. And
Give your name.
Issues are not for medical care. It's because they are rather having a fulfillment.
Oh,
I have to.
yours is 164 point? What is their height?
Above 164.5.
Ah,
Point minus height.
you have been kept as withheld.
Yes.
Although as per that notification,
Yes.
it could have been
There is
given.
a direction.
Ah.
Yes, my lord, can you see?
Hello,
Have to obtain instruction why with the Lordship.
obtain instruction next week. Short.
Lordship.
Where is this? In Assam? Where is this
I have
held?
to obtain it from the CRPF. Lordship.
America.
They are the
Amerigo.
CRPF.
Amerigo, it's too far off. Mr. Roy has to walk. Huh? Okay. Issue notice making it returnable on 6th of February 2026. Mr. S.S. Roy accepts notice on behalf of the respondent numbers 1 to 9. Extra copies of the writ petition be served upon him during the course of the day. The grievance of the petitioner herein is that the petitioner's name has been kept in the withheld list, though the petitioner has otherwise qualified. Full stop. The learned counsel appearing on behalf of the petitioner further submitted. Petitioner or petitioners?
Petitioners.
Have other qualified. The learned counsel appearing on behalf of the petitioner submitted that there was a deficiency in the height inasmuch as the height of the petitioners were in between 164.5 to 165, but below 165. And accordingly, all the writ petitioners have approached this court in various writ petitions, and by a common judgment and order dated 2/12/2025, the learned coordinate bench of this court, applying clause 2D of the office memorandum dated 25/2015, held that the petitioners whose heights have been recorded and measured during the physical standard test as 164.5 cm and above, but below 165 cm, are entitled to be rounded off to 165 in terms with clause 2D of the office memorandum dated 25/2015, and declare them eligible to participate in the subsequent stage of the recruitment process, that is the detailed medical examination. The learned counsel therefore submits that to the instructions of the petitioner, to his instructions, the petitioners have also crossed the detailed medical examination.
Not called for.
Not yet called for.
You have not been called for. The learned counsel therefore submits that in view of the specific directions passed by this court, the petitioners ought to have been therefore called for a detailed medical examination. But the petitioner's name have been kept withheld. Also, Mr. S.S. Roy, the learned counsel appearing on behalf of the respondents, shall obtain instructions why, in spite of the directions passed by this court dated 2/12/2025 in the various writ petitions, the judgment enclosed as Annexure 5 to the writ petition, the petitioners have not been called for the detailed medical examination. List accordingly. What? Corrects.
Correct. But the doctor from the, what, it says lordship 2.5 and ours says it 2.7 only.
It says 2.5, that is normal, my lord. And
But as per our,
their report, my lord, is 2.7,
Where is the recruitment?
that is mild, my lord.
Where is the doctor examination?
Yes.
page 50 is the Guwahati Medical College. Now our rejection by
Guwahati Medical College, no radiological. Where is the review medical board?
Yes.
page 47,
47, it is amended, my lord.
What amended?
that
TRS
report,
my lord.
Huh?
that report has been amended.
46 is the first report, my lord. Yes, 46.
Now, where is the review medical board?
Yes, the medical board is 48. my lord.
Unfit on account of pectus excavation. Okay, now what has happened?
Have taken a-
Then you took a test in Guwahati Medical College.
Yes,
After that,
Yes.
on 6th of December. And what does he say?
It says, Lordship, no radiological features of pectus have been noted. Haller index is 2.5. And in our report, Lordship, Haller index is 2.7, which is not acceptable, Lordship. Suggested mild pectus.
No cruel illusions, no radiological features of no radiological features of pectum are noted.
But
So
Haller in-
this is subsequent thereto.
Haller,
At hospital.
And you have submitted a representation here. Then what happened? After that?
No communication.
Oh. And as per the detail, what do they say about this thing?
the report is on page 47, Lordship. The radiology-
Page 47 is okay.
Reason for medical unfitness also pectus.
This is on 112.
Lordship.
This is given by Hyatt Hospital.
Yes, we have referred him, Lordship.
2.7
Lordship.
suggests mild pectus excavation, whereas Guwahati Medical College says something else.
2.5.
Then whom should we trust?
EMC the Malad.
But this is-
And Hyatt hospital. Malad is
Hyatt,
there.
Lordship, is our,
Hyatt is yours.
yes.
So then,
EMC should be trusted. Malad.
But
EMC
it is
doesn't
not
have-
that, it was not there, it was there.
huh?
Pectus excavation is there, is noted.
No radiological, no.
Radiological was not there, but pectus excavation noted Haller index is 2.5. And in our report, Haller index measuring 2.7 suggested mild pectus. This was our report, Lordship.
And whether mild pectus is one of the grounds of
Yes.
rejection as per this
Yes.
uniform? General
pectus is
examination,
noted here, but-
pectus,
Pectus,
where is it?
Mild pectus is not noted here. Whether it
Then-
is acceptable or not. Malad.
the
Minor
pectus-
acceptable, is it there?
Yes, that is there. Minor acceptable is, pectus is not there. Malad.
62. Not there.
What is this
This is
pectus?
this is some
Chest,
instances given, my lord. This is some instances given, my lord. Minor acceptable details.
Now, if the instances are not given, then you have to look into in 6D. Isn't it 2D? 2D is where? Oh, no, not 2D. Where is that? 2E.
Page 69, my lord. Page 12.
is not.
There is another document now. Where is that? Revised. Yeah.
Because
This, where is that document? Yes, this one.
they have to
2D,
correlate-
6D. Review may obtain opinion of the concerned specialist or supervisor of the government medical college and hospital in case of doubt.
Hyatt is our
Government?
Lordship, as per CGSE, it is,
CGSE is the government.
we have recommended this hospital for
Therefore, in case of rejection in the review, clinical findings should be corroborated with
the X-ray reports.
conformity test, investigation, opinion of the government hospitals, medical colleges, government approved private medical centers.
Lordship. Hyatt is our empaneled hospital, Lordship. CGC. CGHS. Health is our empaneled hospital, Lordship.
But what is this pectus? What is this
That-
pectus?
my lord.
In the chest,
Huh?
The chest, my lord. There is,
What?
my lord, page 69, my lord.
Pec- not
Pectus
clear.
excavatum.
Page 69.
Polar index measures 2.7. Suggests mild pectus excavatum. What is this? Nobody understands it.
Page 69, my lord.
Huh?
Page 69, there is
Yes.
a picture, my lord.
69.
It is not
clear.
clear, but in the chest. my lord.
Hello. Taking up this bench, I may later on become half doctor.
Half doctor.
Ah.
Also, we are also being half
Huh?
doctor. We are also half doctor.
They already become. Dr. Malad.
Okay. What is this?
This is like, they would like something like this.
Is done with the candidate standing up, so and so extended above, so and so the hands being in back. Chest wall is looked for deformities, malformations, including but not limited to so and so. Ah. Understood. Mild. এইখনত লিখক আপোনাৰ সেইখনত এম খানৰ নিচিনা হ'ব এইখিনি লিখি তাৰ পিছত এইখিনি লিখিব এটা পেৰাগ্ৰাফত আগতে ৰিপ্ৰেজেন্টেশন দিয়া নাই বুলি কোৱা আছে ইয়াত লেখক the petitioner had submitted the representation no yeah. After the opinion rendered that the petitioner was unfit on account of pectus excavatum. The petitioner approached the Guwahati Medical College and Hospital and the professor of radiology. Where is his signature? Professor of Radiology, Medical College Hospital had given an opinion on 6th of December 2025 that no radiological features of pectus excavatum noted bracket Holler index is equals to 2.5. It was also opined that the HRCT reveals no insignificant abnormality. Full stop. Pursuant thereto, the petitioner had submitted a representation dated 8/1/2026 through, what is this? Through registered post. However, the said representation have not been considered, and under such circumstances, the petitioner has approached this court. By you give a fresh representation to that respondent number so and so. Huh? To the respondent number so and so, respondent number 5. 5, na?
6, Lordship.
To the respondent number 5, they will consider within 10 days. Disposed.
My lord, in this case.
Yes, Mr. Dingia.
Case, my lord, issue my lord, transferred to the Northern State, my lord.
Huh?
Northern State, my lord. Accordingly, my lord, he joined, my lord, on 2/9/2024, my lord. My lord, he's going to retire, my lord, tomorrow, my lord, 31st January, my lord.
What is this? I don't understand your case. Tell me, what do you want?
It's not transferred, my lord, to the Northern State.
Ah.
Accordingly, he joined, my lord, on 2/9/2024 at Frontier Headquarters, my lord, Itanagar. My lord, what happened, my lord, and he is going to retire, my lord, on 31st January, my tomorrow. My lord, during that period, my lord, he availed a GPRA quarter, my lord, at last place of posting at New Delhi, my lord. My lord, there is a rule, my lord, rule 40, Roman 2, my lord, for 6 months, my lord, extension after retirement, my lord. So a petitioner filed, my lord, representation, my lord, till today, my lord, no, my lord, response from the, my lord, respondent number 2, my lord. It is, my lord, petitioner, my lord, the
Where? Where is your representation?
representation, my lord, the page 76, annexer Q, my lord.
And from the I so and so, and presently posted at Northeastern India, which is a non-family addition. I was there. But as per the office, posted to the non-family. Where is it permissible?
My lord, there is a rule, my lord, kindly see, my lord, the rule, page, my lord, annexer, S, my lord, page 90, it starts from page 90, my lord. Relevant portion, my lord, kindly see, my lord, page 19, page
Huh?
100, my lord, 101. my lord.
101.
40,
Rule?
constitutional- Rule 40, my lord, 40.
The
Page
allotee may,
101.
subject to the conditions laid in these rules, be permitted to retain the accommodation on the happening of any event specified in column 2 for a period specified in the corresponding entry in the demand thereof, provided that the accommodation is required for the bona fide use of a year. Resignation, dismissal, removal from service, termination or unauthorized leave without permission, compulsory retirement, and for non-regular 1 month on demand. Retirement, so and so. Eligible, ineligible, retirement, voluntary retirement, terminal leave or compulsory retirement under human retirement on deputation, permanent transfer to a place outside from the existing place, when ineligible human office instance, so you want to be on B,
Yes, sir. Roman 2.
40,
40.
1, the table,
What?
Roman 2.
Page 102, yes.
Yes, madam, what do you say?
Lordship, may kindly see page 72, office memorandum, Lordship,
72,
70, page 72. By this
72,
office
na?
memorandum, Lordship, the benefit of
As per the note,
retention of
press
women
junction at the last place shall be granted to group A officers, including with immediate effect in case of the so and so. However, provisions of such retention of so and so as declared by the AR shall remain in force. Moreover, the retention already granted to such officers who have earlier posted in demand will also be withdrawn, subject to any stay already granted by any court of law against any vacation order to the allowed to vacate the AL if it is by so and so. So you mean to say, in view of the office memorandum, even he is as on date also not entitled?
Yes, he is not entitled, Lordship, and he is retiring tomorrow, Lordship, and now his prayer is confined only to the extent of his retaining the
For another 6 months.
6 months. In this aspect, take instruction next week, it may be fixed, Lordship.
My lord, my learned friend told my lord, rely my lord that 6 October 2022 is just notification, my lord. That notification already stated, my lord, by the honorable court. My lord. I have stated, my lord, there is a order, my lord. And my lord, even my lord, there is subsequent notification also, my lord.
Next week, Lordship, it may be fixed. I will place the instruction.
Annexes, my lord, kindly see, my lord, there is subsequent notification, my lord, 7-8, my lord.
Huh?
7-8, my lord, for a time, my lord.
Page?
Page 74, my lord, kindly see. Even my lord, the rule, my lord, they cannot, my lord, override, my lord. There is a, my lord, specific rule, my lord.
It is, Lordship, in respect of non-family station only. As for page 72 OM, Lordship, Northeast is not a non-family station. This benefit has been withdrawn in respect of Northeast, Lordship. Only Ladakh, Jammu, Kashmir, on these places, Lordship, this provision is applicable. The OM dated 7th August 2024.
There is no stay to that notification.
Yes,
No
Lordship.
course action, my lord.
No course
Against
action.
that person,
Lord.
Yes,
that,
My lord, even my lord.
are you the same person?
No, my lord.
Well then,
yes.
my lord, kindly see, my lord, the notification cannot overrule, my lord, where did, my lord, article 309, my lord, notification, my lord, kindly see Annexure S, my lord, page 90, my lord.
But this OM is still in force, Lordship.
No, you see, the notification may be in challenge. This is under 309 rules.
This is a policy decision,
I humble
Lordship.
prayer, my lord, representation may dispose of within a, my lord, fixed date, my lord, till then, my lord, no, my lord, the proceeding
Lordship,
takes
next,
merits, my lord.
it may be taken up next week, Lordship. In the meantime, I will place the instruction, Lordship.
But tomorrow, my lord,
On the basis of instruction, it may be
tomorrow is
disposed of.
my last date of my service.
Lordship, he is retiring next week, Lordship. Till next week, you will remain in.
We have it on 9th,
No, Lordship.
and 9th, don't disturb him
Lordship,
till 9th. You file your affidavit by 6th.
Lordship.
Okay? Issue notice making it returnable on 9/2/2026 at 2 p.m.
Lordship.
Miss RDB accepts notice on behalf of the respondent numbers 1, 2, and 3. Extra copies of the petition be served upon the petitioner, upon the respondent, upon her during the course of the day. The case of the petitioner herein is that the petitioner is posted at Northeast Frontier Headquarters ITBP Itanagar, which is a non-family station, and he was earlier allotted General Pool Residential Accommodation, quarter number 364, D Roman 2, type 5 capital A, at Vinay Marg, New Delhi 110021. Pustab. It is the further case of the petitioner that the petitioner was allowed to retain the general pool residential accommodation at the last place of posting on payment of normal license fee. Pustak. On the ground that the petitioner was stationed at a non-family station. The petitioner is retiring on 31/1/2026, and the petitioner has submitted a representation to the respondent authorities to allow the petitioner to retain the said license, said accommodation for a period of 6 months from the date of his retirement, in terms with clause 1 Roman 2, in terms with serial number 1 Roman 2 of the table appended to Rule 40 of the Central Government General Pool Residence Accommodation Rules 2017. Pustak. The same, however, have not been, though recommended, you've been recommended, but not yet accorded. And as such, the petitioner has approached this court. Ms. RDB, appearing on behalf of the respondents, however, submitted that by an office memorandum dated 6th of October 2022, the posting at the northeastern region is no longer included as a non-family station. And as such, no retention is permissible. The Learned Council therefore submits that as no retention was permissible at all, the question of further retention beyond the period of, for a period of 6 months after retirement is also not permissible. In that regard, the Learned Council referred to the office memorandum dated 6/10/2022. Mr. L.N. Hingia, however, submits that in spite of the office memorandum dated 6/10/2022, in similar circumstances, certain interim directions have been passed not to take coercive measures by this court in the case of Prasan Gautam and 13 others versus the Union of India. In WPC number 925/2023. It is the opinion of this court that as the petitioner is otherwise retiring tomorrow and without and if certain interim protection is not so granted today, the irretrievable injury would be caused. Apart from that, a question duly arises as to whether the office memorandum dated 6/10/2022 can override the provisions of Rule 40 of the Rules of 2017. Under such circumstances, an opportunity is given to the respondents to bring on record their stand by filing the affidavit by 6th of February 2026. The matter would be taken up on 9th of February 2026 at 2 p.m. In the meantime, no coercive measures should be taken as against the petitioner in the present residential accommodation wherein his family is residing at New Delhi.
Medical malord, including LDC malord, is 47 million. This petitioner was sent to Suruksha Diagnosis Center, and as per the opinion, it's referred. Reports and opinion reveals minimum scoliosis. Hence, the candidate unfit due to scoliosis, abnormal curvature of spine. Case 47. Doctor's opinion and reports are not available to see. And petitioner said, take up at TMCS case 49.
GMCH report is also mild scoliosis towards right, marking an angle of
Not deformity.
Scoliosis is deformity. As per guideline, scoliosis is as per guideline. Scoliosis is a ground for rejection. It's a general ground of rejection. It is on 65.
You see, the review, the medical examination, which was conducted by the Guwahati Medical College, also says that there is mild scoliosis.
Yes, 13 degrees. But
Then
medical guideline.
medical guideline says what?
Is scoliosis. Degree is not mentioned, my lord, in the guideline. my lord.
Mild or whatever may be, what is there?
But
Scoliosis is there, Lord.
I have a, my lord,
Page 65. Abnormal curvature, point, general grounds of rejection, 6. 6 and 13. 6, 13.
Where?
6, 13, at page 65.
6 number?
13. General grounds of rejection, thereafter 13. Abnormal curvature of
No, serial number.
serial number 13, 13.
Abnormal curvature, exact name, yeah, scoliosis. To be specified. It is there.
yes, scoliosis, this is mild, my lord, but GMC says 13 degree, my lord.
So,
And my lord, they have one address, earlier advertisement, my lord, in the same authority, which says below 15 degree can be accepted, my lord. More than 15 degree is, my lord.
Where?
There is earlier advertisement, my lord.
Earlier, not this.
But the-
this one did not.
How, my lord, medical condition is the same, my lord. This is, my lord, below 15, my lord, that is not medical deformity, my lord.
Can't help it.
That cannot be changed, my lord. That is there. And my lord, petitioner was sent to my lord Stroke Diagnostic Center. Their report is not, my lord, supplied to me, my lord. And kindly see, my lord. Page, my lord, 769.
No, when there is scoliosis, mild scoliosis towards right angle, marking an angle of 13 degree.
Yes.
Then? And this must have been based upon some report.
Yes.
Ortho opinion taken. Then,
That opinion also, my lord, kindly see, my lord.
where?
Page 47, that is before not submitted to me, my lord, but in the rejection itself, it is, my lord, mentioned, page 47. Reports and opinion reveals minimal scoliosis.
Huh?
Page 47, kindly please. What's the opinion taken thereafter, my lord?
Guideline says also abnormal curvatures of spine. Guideline says, and here also reflected abnormal curvature of spine. In page
Medical
47.
opinion, that does not say so, my lord. They have taken medical opinion from Dr. my lord. That medical opinion does not say, my lord, abnormal, my lord.
Where
That
that-
report may be, they may produce my record, my lord. Record may be produced, my lord.
You see, Mr. Ahmed, you have to understand one thing. Do you know why this medical examination is taken? Are you aware of it?
One has to be fixed, my lord.
No. Tomorrow, when you are appointed, these will be the records.
Yes.
Okay. Now, if these are the records and you have accepted it, it will be deemed that you didn't have anything. If there is an aggravation to this and you have to take a disability, you are asked to be retired or you are asked to go out of the service, then you will be entitled to disability pension throughout your life. So therefore, they screen it at this point of time. That look here, under no circumstances, if this is there, we have a big problem. If this particular thing is going to aggravate or not.
My lord, one thing, whether this is, my lord, functional disability is there, that is not mentioned in the review report.
It's not a functional, whether it is going to aggravate is the question. Now, whatever may be, the Guwahati Medical College also had given an opinion
Yes.
that there is mild scoliosis or something. Now, whether this mild scoliosis is not acceptable to them is a different thing. can this court sit over them and say that mile, this is the degree of mile you should, unless the guidelines say so?
Guideline does not say anything, but their own.
No, no,
assessment.
the guideline says something.
Equality.
Scoliosis, and this is there.
And is 69 times similar.
So,
How
Anil,
to my lord, how to my lord? We said my lord, page 69 my lord,
page,
69, 69,
yes,
page 69, 11 my lord, spine and scoliosis joints. The below is scoliosis. Look for the following sign. One shoulder
where?
in the below my lord, scoliosis. Page 69 below my lord.
Page?
Page 69.
Ah.
69 below my lord.
Scoliosis, look for following signs.
One shoulder. is
Look for one
back,
soldier is higher than the other.
One shoulder.
One soldier blade sticks out more than the other. One side of the rib cage is Iman, appears higher than the other. One hip appears higher or more prominent than the other. The waist appears uneven. Body tilts to one side. One leg may appear shorter than the other.
These are the parameters, my lord. But nothing of the parameter mentioned in the my lord into rejection.
Now let us see the opinion given by the Guwahati Medical College.
Page 49. 49 and opinion of the there is 50 my lord.
Here also not mentioned.
No. Heard Mr. H.R. Ahmed, the learned counsel appearing on behalf of the petitioner. Ms. S. Bolwa appears on behalf of all the respondents. The petitioner herein is aggrieved by the rejection of its candidature for the post of Constable GD in the Central Armed Police Forces pursuant to the notice dated 5/9/2024 on the ground that the petitioner have been declared unfit by the Review Medical Examination Board due to scoliosis, SCOLIOSIS, bracket abnormal curvature of the spine. This report was given on 24/11/2025. The petitioner thereupon appeared before the Guwahati Medical College and Hospital, and a X-ray was conducted in the dorsal spine, bracket AP and LAT view, wherein also it was opined that there was mild scoliosis towards right, marking an angle of 13 degree. Full stop. The petitioner thereupon also submitted a representation dated 8/1/2026, but the same was not considered, and as such, the petitioner has approached this court. Full stop. This court have duly taken note of that in the detailed medical examination which was conducted on 17/11/2025, it was opined that the petitioner had inverted comma dorsal scoliosis towards right, inverted comma closed, RT, right to RT question. Thereupon, an expert opinion upon the request made by the petitioner for a review medical examination, an expert opinion was taken from the orthopedic surgeon or from the orthopedic,
Diagnosis,
from the orthopedics
Yes, that's it.
department, and wherein it was opined that the petitioner, wherein it was opined that there was minimal scoliosis. And under such circumstances, the Review Medical Examination Board declared the petitioner unfit due to scoliosis, bracket abnormal curvature of the spine. Full stop. The documents, the materials which the petitioner has placed before this court of the Guwahati Medical College also opines that there is mild scoliosis. A question, however, arises as to whether a mild scoliosis would be the general ground for rejection, taking into account clause 6, bracket 13 of the Uniform Guidelines for Medical Examination Test for Recruitment in CAPFS, NSG and AR. More particularly when at clause Roman 11, the uniform guidelines stipulates what is required to be looked into. Full stop. Next. This court does not have the expertise to decide as to whether the opinion so rendered by the Guwahati Medical College would bring the petitioner within the purview of the general grounds of rejection, more particularly clause 6, bracket 13, read with what is required to be looked into in terms with clause Roman 11 of the Uniform Guidelines. Full stop. Under such circumstances, this court therefore disposes of the instant writ petition with a direction upon the respondent number five to ascertain on the basis of medical opinion and the opinion so rendered by the Guwahati Medical College that the petitioner has mild scoliosis towards right, marking an angle of 13 degree, as to whether the same would fall within the ambit of the general grounds of rejection as stipulated in clause 613 of the Uniform Guidelines. The said aspect be considered and decided within a period of 15 days from the date a certified copy of this order, along with the original report of the Guwahati Medical College and Hospital is served upon the whom?
This no 4 months.
Huh?
Let us refer on 4 months.
No, 4 can't do it. Upon the, who is the head of this?
Presiding officer, review medical board.
The presiding officer of the review, the presiding officer of the respondent number 5, isn't it?
Yes, respondent number 5. Here, according to petitioner, MRI was conducted by the respondent authority.
Okay.
Yes.
You will decide. I'm not going to
Yes.
decide all this.
But
Above the
Okay.
writ petition stands this.
for admission item 18 and 19.
What is this so old matter?
One of the matter, Diego has been recently engaged.
Huh?
My lord, you said Diego has been recently engaged in this matter. The earliest out of councils, the matter was withdrawn from them. Today, my lord, there's some difficulty, so they asked me to appear. On the last occasion, my lord, the state's presence was sought for. And, my lord, there's an order of this honorable court where the state was directed to inform the court as to whether the directions in Upendas can be applied to the petitioner. Ordered it 5/10/2022, my lord.
What are these people who are asking for?
My lord, basically, he was appointed as a temporary copyist in the institute. He was appointed as a temporary copyist
Ah.
in the office of the learned member for Honest Tribunal number 1, Kamrup Metro, on a fixed pay, way back in 2008, my lords. And since then, he has been continuing. And he was aggrieved because his arrears and the fixed pay was not paid regularly by the authority. And hence, he had preferred a representation that was pending, and hence this instant writ petition was filed. And there was an interim order of this court because of which the arrears and the payments have been paid as of now. And an additional prayer was also made to regularize the services of the copyist because of the long services that were rendered to them. My lords, it is a fact that we were appointed temporarily, my lords. But from time to time, our appointment was sought for and it was sanctioned from time to time by the authorities. And my lords is aware of a recent decision of the Honorable Apex Court in Jaggu and Dharampal, in which the Honorable Apex Court has clearly observed that if there has been an uninterrupted service rendered by temporary
No,
workers.
my question is this.
My lord.
Jaggu and all these things are there. But whether there is a sanctioned post of copyist or not.
Well, my instructions are that the sanction posts are there. In fact, my lord,
Now, in that post, did you participate in the advertisement or not?
my lord, when I was appointed way back in 2008, there was no advertisement as such.
Forget about that. Subsequently,
No, my lord, because I had been continuing in that post on which I was appointed. I was appointed by the learned member way back at that point of time, because at that point of time, the IMDT Act had been scrapped. And under the Sarvananda Sonowal judgment, these foreigner tribunals were created. And then the state government had raised a proposal before the central government that these are the sanctioned strengths of workers, staff that we will be requiring. And amongst that, the post of copyist was also recommended. However, the central government did not consider that request, and it's still it was pending before the
as
union
of
government.
now, there is no post of copyist.
Later on, it was introduced, my lord.
So how is it filled up?
My lord, so far my post is considered, it has not been filled up.
No,
I
no,
have
no,
been
you were temporarily appointed, but
Yes.
if the that, so you were appointed not against the sanction post. So now thereupon, therefore, my question is, subsequently the post was sanctioned. How that post is being filled up or is it vacant?
subsequently elected.
Mr. Council, you are not understanding whether the post has been filled up
No.
of the copies, post of the copies, because the post of the copies have been sanctioned. Has it been sanctioned or not?
My lord, if you go by the affidavit, till now, my lord, there is no sanction post. They are continuing, my lord, in a fixed pay basis. That is all, my lord. There is no as such sanction post.
That was the
For
instruction.
copies, my lord, no such. This is my affidavit.
Now, the question is, do you require the post of copyist or not?
My lord, that instruction I have to seek. That instruction.
That is the question.
And the thing is that, my lord, unless and until a post is sanctioned, if a post is sanctioned even, my lord, still then, my lord, we have to follow Uma Devi, para 53. Then, my lord, we cannot go for regularization here.
You can go for regularization. I can't direct for regularization.
Yes,
There's a difference.
yes, that is there, my lord.
If I will only go, my lord,
Only one thing is, my lord, Upen Das, whether they will get the benefit of Upen Das, my lord, only that is left. In
That
2017,
cannot happen because it is 10 years prior to 1/8/2017.
that is also, my lord, 1 year short.
my lord, no, sir.
I am appealing for the item number 19, my lord. Under similar circumstances, some order has been passed by this honorable court, my lord, regarding minimum pay scale, my lord. It has been allowed.
Yes, my lord. I'm also covered under that.
My lord can dispose it of, my lord, with direction to examine, my lord. We will examine it. If they fall within the ambit of Upen Das, my lord, we will give, my lord.
Para 22.
Para 22. मला कोण कॅन्सल करू दिसेल ना 5/1/12 गरज नाही
Hmm. Yes, Mr. B. Gogoi. I remember this case when I was taking up these pension matters, those matters out there. This case came to me. So I put a question to you at that point of time. These people were copies who were appointed subsequently. But subsequent to, because your stand was that you follow Upendas, and as per Upendas, we are going to give him so and so. 10 years prior to 1/8/2017.
2017.
Now, if that is the order, that was what it is. So then I was deliberating and the matter went out of, I was not taking up that bench. Now this matter came up before Justice Surana. Justice Surana said that he is entitled to.
Oh.
Now, here the petitioner would also be entitled to the same relief. But the question arises is, you have not challenged this order. This is a very dangerous order.
Yes, yes, my lord, I
Here the finance was represented by Mr. Arbor Pujari. If you remember, this was a matter where Mr. I.H. Saikia was arguing
in fact.
as to whether those persons who were being temporarily appointed post 2007
My lord.
would be entitled to the minimum scale of pay because those other persons have been granted.
Lots of, and they have completed 10 years.
Now the question of 10 years would be counted only post 1/8/2000 prior to 1/8/2017 or any point of time.
Lots of.
Now if that be the clear and it has been given by this court, wouldn't it, you see that it will open up a huge flood of litigations?
10 years completed, my lord, even from today.
Ah,
Then.
this is what has been given. Have a look at this.
Dada, looks me. Finally, my lord, it was settled there.
But this was the matter, you were also there
Yes,
at
yes,
that point of time, if I remember, because you made it a point, and on the other hand, I was saying that as per Jagjit Singh, he's entitled to.
Yes, following the existing one.
Jagjit Singh, he's entitled to. But later on, the fact remains that Jagjit Singh is been held in another judgment to be per incuriam. In the case of All India Bihar Teachers Association 2019-18 SSC,
My lord.
wherein it was not looked into. Because Jagjit Singh gave the minimum scale of pay
Yes.
concept.
My lord.
So this. Now, how do you take care of this? This is if this is the judgment which is given and no appeal has been filed, you will have here the petitioner was appointed in 2008.
Here, my lord, probably, my lord, the main point that was taken into consideration was that, my lord, similar copies were being given the benefit of.
Here also the same. But the fact that in one of the paragraphs he said that the government said 10 years, but did not say with effect from 1/8. And therefore, anybody completing 10 years would be entitled to. Which means in all other cases also, not
Yes.
here, many cases
yes.
this will follow.
Well, I will have to, my lord, take a strike.
Did you get the paragraph?
Yes, my lord. Lordship has marked it, there are 8.
No, I have not marked. I don't mark any.
He underlined, my lord.
He has marked. It's okay. Just give me a copy of it. I'll show you which paragraph. But Mr. Borua and you also, both of you have filed the writ petition early, prior to the Upenda. I'll request you to, or ask you to file an additional affidavit, just an additional affidavit incorporating this aspect. Because your prayer is only for regularization. So you therefore will be, you therefore ask that, only one paragraph affidavit. Then I get the, because tomorrow it will be. Kindly see paragraph number 8.
Yes, 8 my lord.
It refers to the benefit to be extended to those persons who have rendered 10 years of service at that point. In the said case, this court did not pass a general order to command the respondent to extend benefit to all those persons who are similarly suited. Nonetheless, benefit was extended by the government of Assam to all master roll workers who at that relevant point of time had completed 10 years of service. Therefore, once the state government takes a decision to extend the benefit of minimum scale of pay to all the employees who at that point of time had completed 10 years of service, the denial of such benefit to others who had completed after the said period would create inequitous situation which would further create two classes of persons having 10 years at different points but getting different scale of pay merely because the other class completed 10 years after 31/10/2017.
No, it's not the decision of the state, my lord. The direction was of the honorable court, my lord. The 10 years till the date of passing of the judgment, my lord, they will get the benefit. And my lord, other health benefits, that was the.
With this judgment, I'm bound by this.
Yes, yes, when probably, my
Now,
lord, it will
now
have to
if
be
you have not
reviewed.
challenged this
You'll have to
order,
file a review, my lord.
huh?
You'll have to file a review because this is not the, my lord, judgment. The honorable court has directed us that those who have completed 10 years till the passing of this judgment.
But this
they will get
judgment
the
was
benefit.
passed long time. 23/5/10/2023.
Probably will have to prefer a review, my lord. Because it says
Because
in
that
the
is all,
said
that
case.
was also this thing which is Justice Surana says is also my opinion.
Lordship.
Because you cannot create an iniquitous thing because the
Lordship.
court has granted only then. Jagjit Singh does not. This Jagjit Singh aspects on the basis of Jagjit Singh that was given.
Lordship.
But to compel it to this amount, it doesn't proper. But now I get more strength.
Lordship. That my lord will have to examine what. to-
You just file one short affidavit, both of you. Okay?
May I pay for it is taking as a part-time, as a part-time member,
Why?
for that additional.
It's okay. Don't make it part of it. You never know. I may sit in this bench or not. But anyways, you do one thing. You file an additional affidavit, both of you. Just put that. Because without asking that, if I give you, it may happen. And put this, what is given in paragraph 8. And so do as soon as possible. Okay. Okay. Mr. So-and-so and so-and-so appears on behalf of the petitioners in both the writ petitions. I've also heard is the finance a party?
Yeah.
I've also heard Mr. B. Gogoi, the learned standing counsel of the finance department. Mr. Ardor, who appears on behalf of the member foreigners tribunal,
Yes.
on behalf of the other respondents, and Mr. B. Chakraborty, who appears on behalf of the accountant general, C. Borua. Full stop. The learned counsels appearing on behalf of the petitioner submits that though the petitioner have sought for regularization, and they do have a claim taking into account that the petitioners have already rendered almost 17 years of service on a fixed pay basis, and the inaction on the part of the respondents in creating a sanction post to accommodate the petitioners. But the petitioners are also entitled to the minimum scale of pay. Inasmuch as all other copists inasmuch as copies similarly situated to that of the petitioner have been already directed by this court in the case of Rupjyoti Das versus the state of Assam and others by the judgment and order dated 5/10/2023 to be entitled to the minimum scale of pay. Full stop. This court also takes note of that this aspect, however, is not a part of the pleadings. The learned counsel appearing on behalf of the parties, petitioners, therefore submits that an additional affidavit would be filed. And taking into account the provisions of Article 14 of the Constitution, the petitioners should also be given a similar relief. When?
30th of February.
Huh?
30th of
Third week. I won't be there. Anyways. Hello.
Any date after the 10th, my lords. Any date after 10th of February.
After 10th, huh? Let's have it on 13th. List the matter on 13th of February 2026.
On 30th. Could be on the 14th.
14th is closed. You see, 12th difficult. 13th, let us have it. No, don't worry. Anybody else may be there. Don't miss the chance. 13th. The additional affidavits be filed on or before 11th of February. Detailed এটা ওটা বলি। Partner, no. If you are there doing it, good. If you don't do it, you miss the bus.
We posted on 13.
What has happened?
Probably, my lord, it was discontinued. That monthly remuneration, my lord.
Paid? So what is
Let it be,
there?
my lord, 13, my lord.
Latest instruction that we have, the latest instruction that we have is the petitioner received an amount of 1,78,000 in the month of November 24. Person thereto, the petitioner received the amount of 83,000 in the month of February. Person thereto, no more further payments. So the petitioner approached the DLSA as liberty was given in the order passed by the Honorable Court.
Let it be on 13, my lord. I have already intimated the authorities. I will come up, my lord.
Why this matter needs to keep on coming? They have already given this thing. When should it come?
13, my lord.
1-3.
Yes. Let me place, my lord, why it has been.
List the matter on 13th of February 2026. In the meantime, Mr. B. Gogoi shall obtain instruction as to whether further payments have been made in favor of the petitioner. Mr. Gogoi, ask your people not to, this should not come again. It looks nice. Into. Okay. 20. Okay. ফটো কৰিব নিদিব এইটো আপুনি প্ৰিন্ট আউট এটা ফটো ষ্টেট কৰি দি দিব Yes, what is this?
Other pertains to family pension benefit.
Directed to appear before the coordinator mediator for a convenient parties are iman. What has happened?
Petitioner is yet to receive the GIS and the gratuity.
Mediation failed.
Yeah.
Mediation failed.
Petition-
Huh?
Petition has failed.
I know it. Nothing is going to happen.
Last instruction, the
He has
GIS
not
was
completed 20 years of net qualify and therefore his a legal heir would not be entitled to death cum gratuity, time and gratuity. To the PWD. Yes. What is your instructions? Not be issued directly in the to sanction the family pension unit. Who is appearing?
My lord, I have an instruction, my lord. I just received the instruction that it's in process. GIS, my lord, it's in process. It will be given soon. And 28 days area salary has been already given.
Gratuity still remains pending, you know, that has been.
Gratuity part, my lord, they are working on it, my lord. That instruction they will be giving me in a week. That is what. There are 3 issues. So, my lord, gratuity is not very sure how they will do it. That is what they are working on. That is what the additional chief engineer told me today, my lord. 2, that area salary has been given and GIS.
What about pension?
Pension we have received.
You are receiving the pension.
Pension. Paid.
You have received. So only is the gratuity.
Gratuity, the GIS.
GIS you are
GIS
paying
is
in
per month.
24 hours. How much? 24 days.
No, area salary. 28 days area salary. That is
28 days area salary you have paid.
paid.
I am not then. Are you, what about the GIS?
That is, my lord, it's in process.
So therefore, how many days?
My lord, let this matter come off after 10 days, so I can get the whole instruction.
It's a 2015 matter. It
I
doesn't
understand,
look
my-
nice.
that is a my lord. My lord will fix the matter when my lord is coming back.
Well, I'm not coming back before going. No, not after coming back. Before going. Before going. This matter, I'm taking it up on 12th at 2 p.m.
My lord.
Full stop.
Outstation matter of the date fixed.
What?
I have a matter fixed before the Arunachal bench of that particular day, your lordship. So
Who?
I have a matter fixed before the Arunachal bench on that particular day, your lordship.
So?
If at all it's possible for the court to adjust any other day, your lordship.
Chalo. This court, taking into account that a matter is of the year 2015, wanted the matter to be listed, wanted to fix the matter on 12th of February 2026 so that the matter could be disposed of expeditiously. However, the counsel appearing on behalf of the petitioner submits that he has inconvenience, lists the matter on 9th of March 2026. Yes, what has happened? Mediation failed. These mediations can't happen in these type of matters. Entitled to get pension under the Assam, however, he has been denied his benefit. Why?
One day, we are supposed to receive PF balance and
Yes.
NPS balance, which have been deducted from my salary. We have received GPF amount. And only, we are supposed to, as has.
Not
decided
issued
to-
directly.
Everything is settled now, Lord.
Petitioner under the.
It is-
Huh?
GPF account-
Why?
Everything is settled, Lordship. Now, Lordship, this is pending before the Director of Accounts and Treasuries, Lordship.
Director of Accounts and Treasury is the Finance Department. No, good.
My lord, respondent number 4 is Treasury Officer, New Silchar.
With reference, I have the honor to say the proposal for drawing up contributional amount for tire excluding government employee due to exit from NPS due to superannuation in respect of so and so retired of the plan number. His total holding as on so and so is demand, total contribution in his account is so and so and is demand. This is for your information. He is NPS.
NPS, Lordship.
You are NPS. Then-
No, he's getting regular pension, but in the Intern department, they have deducted NPS contribution. So that self-contribution, it has been decided it should be paid.
Then he come
That
to OPS again,
contribution
Lordship.
towards
Initially NPS, then he come to OPS, Lordship.
Ah.
So in whatever amount is deposited in the NPS, that amount is, Lordship,
He's entitled to,
entitled to, Lordship.
and that has not been released.
This is before the treasury now.
Oh, you have taken his money. So you pay with interest,
Lordship, already before the treasury.
18%?
It is already before treasury, Lordship.
Understood. Let them pay with interest.
Lordship, it is sanctioned by the.
When did the
AG,
petitioner
Lordship.
retire?
It is sanctioned by the AG office on 4th November 25. Lordship.
Understood. When was the interest, the year given, petitioner retired? Okay. It's okay. 53,100. Now, this is the pension.
Lordship, this is paid.
I'm not on the pension. I'm only asking, when did the petitioner retire?
2019.
Huh?
Yes,
2019.
he has been retired on 2019 and he is receiving normal pension under OPS 1969 rule.
So you won back your contribution.
Yes, Lord.
My contribution.
So
No,
from
this is
2019 onwards till date, paid 9% interest. You have used it for infrastructure purpose, I suppose, or paying contractors' bills. Isn't it? Tomorrow, the petitioner may also say, wherever any irrigation project is there, the brick where I stand is mine. When are you paying? Who is the director here? Director of AIA is where? Oh, Treasury Officer.
Lordship.
The Director of AIA, we make him a Director of Accounts and Treasury.
Lordship. It is pending before them, Lordship. Now.
This is the Director of Pension earlier.
Lordship. Lordship.
Mr. N. Upadhyay, appearing on behalf of the Irrigation Department, submits that the petitioner's holding, total value of holding as on 4th of September 2025 is rupees 8,42,195.30, and the total contribution in his account on 4th of September 2025 is 3,62,056, and the total gain on 4th of September 2025 is rupees 4,80,139.30. In that regard, the Treasury Officer, New Silchar Sub-Treasury, have informed the Director
Of
of
Accounts and
Treasuries Assam to do the needful, and some time is required in that regard. Mr. Naik, you are finance. Mr. Naik, P. Naik, who appears on behalf of the Treasury Officer, New Silchar Treasury, that is the respondent number 6, as well as also the Director of Accounts and Treasuries Assam, shall apprise this court when further steps are going to be completed as regards the disbursal of the amounts to which the petitioner is entitled on the basis of his contribution. This needs to be taken on an urgent basis, taking into account that the petitioner have retired in the year 2019. List this matter again on 2nd of March 2026 for an update. The instruction so placed by Mr. N. Upadhyay is kept on record when marked with the letter X.
Obliged.
Instruction to the.
Premediation, nothing happens.
relates to non-payment of retirement benefit plus fee. Last occasion, they have already calculated that amount plus fee whichever I am entitled. But whether my client has received or not, I have no instruction lawsuit.
How much? 567, 540. You have received it?
I am, because I could not contact my client.
Why the client doesn't want to contact you
Yeah, that's,
after receiving the money?
pardon.
My lord, they were asked to file a affidavit regarding the name, my lord. The petitioner name is, in the official record, it is Amal Bora. In the bank passbook, it's Amal Chandra Bora, so it could not be released the amount.
Okay. Where is that instruction?
It is.
This is as on 2024.
Yes, my lord.
Now the total amount payable is 5,67,540. So the petitioner requires
He has
to,
not filed the affidavit till now.
before? Before whom?
Before the Khadi board, my lord.
Before the Assam Khadi.
And Village Industries. Board.
Huh?
Assam Khadi Village Industries. Board.
So he needs to file that
File, yes,
application.
yes.
But how,
Discrepancy in name, I think.
huh?
Some discrepancy in.
In the name as well as the account number.
Yes,
So there it is there for you. In the service book, it is Amal Borua.
Amal Bora.
But in his bank account is
Yes,
Amal
Amal
Kumar.
Chandra Bora.
Huh?
In the bank account, Amal Chandra Bora.
Amal Chandra Borua. Commission affidavit that Amal Bora and only are the same person. So you do one thing, you intimate, and the client is not contacting you. What to do? It is informed. This court has. It is being informed. That the petitioner is entitled to an amount of rupees 567,540. However, the Assam Khadi and Village Industries Board is not in a position to make payment to the petitioner on account of the petitioner's name appearing in the service records as well as in the bank records are different. In the service records, the petitioner's name is Amal Bora, whereas in the bank records, it is Amal Chandra Bora. Full stop. Under such circumstances, the petitioner was also intimated to submit an affidavit before the Assam Khadi and Village Industries Board that Amal Bora and Mr. Amal Chandra Bora are one and the same person. However, the petitioner has yet to file such affidavit. Ms. So-and-so, appearing on behalf of the petitioner, submits that she would apprise the petitioner about the said aspect. List this matter on 11th of March 2026. In the meantime, the petitioner would be at liberty to submit the affidavit as sought for by the Chief Executive Officer, Assam Khadi and Village Industries Board. The instructions so submitted by Mr. P.K. Munir, so and so, is kept on record and marked with the letter X.
Much obliged.
What is this? Asha worker. People must have lost hope of Asha workers now. What is this notice inviting tender? Nothing remains. Anything? Release the last paid for. What is the matter about?
Appointment of the ASA firm.
Somebody is working?
No, she was selected by the Gaon Sabha, my lord, the petitioner.
The
Thereafter-
National Health Mission is implicated, so in the meantime, no selections for the post of Asa Kormi in Wangsa shall be held till the next returnable. There's a interim order.
No,
Interim order was there. Now what has happened? There's an interim order.
yes, yes, it was stayed.
Then 2020, 6 years have gone. Okay, none appears on behalf of the petitioner on call. Ms. So-and-so appears on behalf of the Health and Family Welfare. Health and Family? You?
And
Oh.
for NHM,
What?
National Health Mission.
National-
Spot number 7.
National Health Mission. Appears for the National Health Mission.
A Bora.
And Ms. S. Sharma appears on behalf of the Health and Family Welfare Department. So taking into account that the petitioner is not represented, for the ends of justice, the matter stands adjourned with an observation that in the circumstance the petitioner is not represented on the next date, comma, the instant writ petition shall be dismissed for non-prosecution. List the matter on 6th of March 2026.
26.
A prayer has been made by R.A. Majumdar. Notice here. What is this?
Only the last order. Party the petition.
Huh? What is your case?
They are supposed to file instructions in the case is that your lordship.
What do you want?
Petitioners are serving as outsourced worker under APTCL, your lordship. There was some exercise.
So to consider the services so rendered as outsourced workers and provide them benefits of the office order, it is so and so. The third is get the benefit of the order. Then what happened? APDCL is not filing affidavits.
My lord, I have my instructions for you.
When?
Today, my lord.
You got your instruction today.
Yes, my lord.
3 years old matter. Today you are getting the instruction.
My lord, the committee has not been considered. However, my lord, it was my instructions of 15/10/2025. Though I have received it today, a committee has been considered for consideration of their cases, verification of their documents. My lord, they could not produce those records, my lord.
It's a speaking order. You need to challenge this also.
Notice was issued, at that moment, one notice was speaking. There's no direction as such. There was no direction to pass the speaking order.
No, you must have submitted some, whereas the petitioners have filed as taking a claim for being released monthly wages in terms with the order. This is a writ petition file. Is there any direction for you to consider?
No option.
Then, why you are considering it?
There's no lordship.
Or as regard to the consideration that is under process, yes,
I have submitted.
there is an order. Mr. P. Das, learned counsel for the APDCL, submits that grievance is under consideration. Therefore, he prays that a matter may be listed after 4 weeks. On the next date of listed, the counsel for the APDCL shall place the instruction as regards the consideration that is under process. Yes, sir, are required to place there with regard to consideration. None has been done. Pursuant to the orders passed by this court, Mr. Bidas, na,
Yes, ma'am.
appearing on behalf of the APDCL, submits that by the speaking order dated 15/10/2025, the grievance of the petitioners were rejected, taking into account that the petitioners could not produce continuous payment records till October 2023. Full stop. In that regard, he has placed before this court a speaking order dated 15/10/2025, which is kept on record and marked with the letter X. Full stop. Mr. So-and-so, who appears on behalf of the petitioner, submits that he would take appropriate steps. Full stop. Mr. Bidas further submits that the APDCL would like to file an affidavit in that regard. Full stop. List this matter again on 16th of March 2026. In the meantime, the affidavit be filed by the APDCL on or before 6th of March 2026. Petitioner given liberty to take action in pursuance to the speaking order dated 15/10/2025, copy of which have been provided by Mr. B. Das to so-and-so during the course of the hearing.
28 and 29. Maybe can find you.
Oh, I can't take up this matter. No. Well, leave the matter before any other bench.
Pertains to compassionate appointment.
What?
Compassionate, it was rejected on the ground for 3 years, when less than 3 years, when the
3 years.
less than 3 years remaining service relation, the division bench is covered by the division bench judgment on first in database 287 of 2023 and analogous matters. Next one, 4 is the MP order. Page number 21 years, relevant pages, page number 38.
What is this pension payment order? You're getting pension?
And the daughter of the deceased.
Huh?
And the daughter, petition.
Unmarried?
Unmarried. Unmarried.
So you're getting pension? Why?
Mother is receiving family pension. Mother is there.
So then?
I applied for appointment here. That has been rejected, page number 38 last. On the ground that I have given 3 years of balance here.
2016.
16.
Yes, I have applied within the year.
So what? 10 years have gone.
It was considered on 2022 year. My case has been rejected in the year 2022. Connection 4, page number 21 year.
Your rejection is of 2022.
Yes, sir.
You approached this court in 2025.
Yes.
We are today in 2026. You are able to survive for the last 10 years. That is Your mother is getting pension. You filed the application in 2000,
17.
2017.
Yes, sir.
2017, if you filed the application means you have 15 years. 2025, you were 24. Okay?
Yes, sir.
So what was your age? Mr. Dhar,
My lord, my lord.
you are good in calculation.
My lord, she is in 25, 27, meaning thereby in 16, she minus 11, that is, she's a minor. 16. There is a settled position of law. We have a following Supreme Court judgment, my lord. Several orders was passed by this different coordinate bench of this court, my lord.
No, till one becomes a major also can apply. There is no quarrel with that. If a person is a minor at that point of time. But the question is, it's a right. It's not a right.
Not
You have
a
been
right.
able to survive 10 years.
Immediacy. That is what, my lord.
Huh?
Immediacy is gone.
Immediate record. This is not there. Hello. Dismiss. It will be Purka's order to cite dismissal. Those both.
One order dated has been 2747/25.
What?
It has been considered in by 14.
I am not going to consider. This is the bad thing.
Order dated 21/1/2000.
I have taken all these things and then also dismissed. Be Purka's order. Huh? That the claim of having in respect to the issue has not been released by the department and therefore. Yes, why? Why you have not got the pension?
But till date, as per rule 148, 1/3,
Huh?
as per rule 148, 1 subsection, sub-rule 3, my husband died while in service.
While?
My husband died while in service.
While it.
He was serving as a SDMNHO School Health at Jorhat under SDCHT Tower. And when a person died in service, while in service, as per 148, 1 sub-rule 3, on receiving information of death of an officer while in service, the administrative authority will send a letter as prescribed in Form 9 to the family of the deceased and ask for necessary formal application in Form number 10. And subsequent to that, on receiving of that documents, my lord, to the sub-rule 3, above pension sanctioning authority will sanction the family pension as in Form 11 and send all these documents along with the service book of the government servant to the audit officer concerned, who will then issue the pension payment order to the beneficiary. But my lord, these were not done with me, my lord. No information, nothing of that sort. I made several representations. First one on, my lord, 31/10/2023, seeking, my lord.
Page.
Page, my lord. Prior to that, my lord, may kindly see, my lord, the next one, page 16, my lord. This is my marriage certificate.
No.
Page 1, my lord. She's to certify that the marriage was solemnized within so and so.
Why the wife's name is blank in the death certificate?
Hello?
Why the wife's name is blank in the death certificate?
My lord, what had happened, my lord? Immediately after, my lord, we have, my lord, no issue, my lord. We are issueless, my lord. And after the death, my lord, immediately thereafter, my lord, the brothers and nephews of my lord, my husband, my lord, they procured this death certificate, my lord.
when I was busy in doing the rituals and all, my lord, immediately at that time, my lord, this death certificate was procured. And thereafter, my lord, they have also obtained one NOK, my lord, next of kin certificate, depriving me, my lord.
Oh, there the problem arises.
Thereafter, my lord, when I approached before the authority.
So your main thing is the marriage certificate.
Lord,
So your trump card is the marriage certificate.
yes. Yes, my lord, I am the legally married wife, my lord.
Huh?
I am the legally married wife, my lord.
Why haven't you filed your affidavit, madam?
Lordship, I have received one instruction.
Huh?
I have received one instruction first.
Instruction won't do. Why haven't you filed the affidavit?
Lordship, complete instruction I have received yesterday, so I need some time to file affidavit, Lordship.
Okay, Miss S. Sharma appearing on behalf of the Health and Family
Yes, Lordship, respondent.
submits that
One,
2 weeks time may be granted to file the affidavit. Yeah, Mr. Borua, you don't have any role now, or do you have a role?
I don't have role only on not allegation, statement is made by health department that service will be maintained by us.
not
But
only, service
that-
role.
Service will be maintained by Nicheli. Then I have received that we are not maintaining this. Our role is proper. Otherwise, no. Because that is.
No, are you going to ascertain as regards the family pension?
We have to receive the pension papers. Thereafter only it will come. Like.
So submits that she would be filing her affidavit within 2 weeks. Lists this matter again on 23/2026. In the meantime, the affidavit be filed on behalf of the Health and Family Welfare Department within on or before 9th of March 2026.
No.
Liberty given to the petitioner to file reply.
Last order. Only peruse the last order of this honorable court also. We have submitted the instruction.
Advertisement has been cancelled.
No, Lordship, there was earlier advertisement was cancelled. And this is selection process was initiated in terms of subsequent advertisement. They are saying that there is a cancellation on the ground that after completion of rationalization process, the post will be filled up. My lord, during this time, Lordship, this instruction they have placed, Lordship, without Lordship relying this, my lord, withholding Lordship this letter, Lordship fantasy, there is a permission of the director to go on with the process and complete that same and submit the proposal, Lordship. That letter, Lordship, they have not disclosed in that instruction. This is the permission they had given. My lord, my instruction is that they have-
Maybe, but you see, this is being issued by the joint director. You see, this is being issued by the joint director. This instruction is from the director.
Yes.
Director says that another advertisement issued on FOIA by the child development officer for filling up the post of the Singh Anganwadi and 39 Anganwadi helpers and completed the process. AI submitted the select list of the outcome of the engagement to the directorate. On scrutiny of the said proposal, it was found that the rationalization process in the Lala scheme has not been completed. From record, it appears that there are 36 numbers to be rationalized, but as per records, only 5 numbers of centers have been rationalized. As such, approval of the sales submitted by the sales has not been accorded from this end. So the director says that I am not granting the approval. Now, who is the joint director to say, kindly do so?
My lord, the instruction that I have placed lordship, that was with the approval of the directors. This is the joint director letter. Last
do you
line,
know?
your lordship may see.
Now, how do you know with the approval? That submit the proposal to the underside for approval of the select list in due course. Where is the approval of the director?
No,
Approval
last
of the
page.
director of here. But this director, this is of 2024.
Yes.
This is of 2025.
No, this is.
No. Here the
25.
director has said, whatever may be here, they have made it process state. But here the director says that no. Post it appears that the advertisement issued by the child development Iman on Iman and conducting the process of IA is contradictory to the notification dated issued by the child development officer himself. In view of the fact the undersigned is not in a position to approve the select list submitted by the Siman Lala.
My lord, my submission would be there. My lord, first advertisement that was issued on 22/11/2023. That was at lordship, I have annexed all this letter. That was cancelled on 30 November 2023.
Who are you?
My lord,
Who are you?
my lord, we are the participant. We have the lordship appear in the selection process.
So you are sure that you are going to get it?
My lord, we are expecting. Let them lordship.
How?
Lordship in the short.
How are you so sure?
In the short list, lordship, I am not praying for direct appointment, lordship. My lord,
That is too far.
my lord.
First
they-
of all, you have to say that whether this court should dismiss or not, that is what.
My lord, what happened, lordship? Cancellation was made on 30 November 2023. And subsequent advertisement that was issued on 4/3/2024. And this letter, lordship, I have placed, this was a lordship issued on 29/8/2024. After that, lordship, the selection process was initiated and lordship, a panel of the select list was submitted to the director for approval. Now, lordship. they
And
are
what did
taking-
the director do?
My lord.
What did the director do?
No, now the director is saying that without completing the rationalization process, my submission would be on that lordship. The rationalization process has already been completed.
When?
That was done by the CDP lordship. If the CDP's instruction or affidavit lordship is placed, your lordship will clear on that. Because CDP has done all these things. And this instruction lordship on 29/8/2024, they directed the CDPO to go ahead with the selection process and submit the proposal. Accordingly, he has done. Cancellation was made in 2023.
Here the director categorically says that I am not willing to approve the select list.
Yes, so that is the wrong lordship, because in
So
view of
rightly
this
or
letter,
wrongly,
it-
forget about that. This is by the joint director.
no, joint director, final last sentence, this is issued as per approval of the director, last line.
Now, this was in 2024. The director now says, unless you allege there is some problem with the director to do so, and this communication that he is not willing to do it.
My lord, in the director instruction.
Where is your
lordship,
allegation that the director is not doing it?
My lord, direction instruction is without disclosing this letter.
Forget about that. My question is, where is your allegation that the director is not approving?
My case is the director has not approved. This is my case, lordship. Our case, lordship. So now.
So the
lordship,
director gives reasons.
My lord, if the CDPO lordship place the instruction, your lordship will clear on that whether rationalization process was completed or not. My lord, my instruction is that rationalization process was completed and some Anganwadi
So
centers.
you
were
mean to say
allocated.
that the director, Women and Child Development Department does not know? He says that rationalization is not done.
My lord, rationalization is to be made by the CDPO. He has done.
It appears that there are 36 numbers of Anganwadi centers to be rationalized. But as per records, only 5 of the Anganwadi centers have actually been rationalized.
Initial advertisement was against Lordship 54 posts. And subsequently, Lordship, after amalgamation, rationalization, subsequent advertisement contains Lordship 47 posts. So, rationalization part has completed. Only some Anganwadi center has been amalgamated. That was the rationalization. That part has done.
You do one thing, you file an affidavit to the director, we'll close it, and you want to go ahead with a fresh advertisement, go ahead.
My lord, my submission, Lordship.
You have no right, you have no right. You have no right business, anyways. Mr. D. Bora, appearing on behalf of the respondent state, submits that in terms with his instructions received on 19/12/2025, the Director of Women and Child Development Development, Assam, have refused to approve the select list submitted by the Child Development Project Officer Lala ICDS project on the ground that the Child Development Project Officer Lala has had conducted the process of selection and finalization contradictory to the notification dated 30/11/2023 issued by the Child Development Office Project Officer Lala himself. In addition to that, it is also mentioned that there were 36 numbers of Anganwadi centers to be rationalized, but as per the records, only 5 numbers of Anganwadi centers have been actually rationalized. Taking into account, the said instruction is kept on record and marked with the letter X. This court is of the opinion that said aspect be brought by way of an affidavit so that appropriate orders can be passed. List this matter again on 13th of March 2026. In the meantime, the affidavit be filed by the Director of the Women and Child Development Assam on or before 9th of March 2026. What is this?
Women said supposed to take instruction last occasion Lordship.
Lordship, this person was convicted in the year 2017. And his revision was dismissed by this court, Lordship, in the year 2019.
He was terminated.
Not terminated. So on several occasions, Lordship, notices were issued, WT messages were sent. Subsequently, show cause notice was also issued in terms of services and appeal rules. He never, it returned showing as addressee not found, Lordship. And ultimately, Lordship, he is claiming that on 12/4/2024, after his release from jail, Lordship, he submitted one representation praying for allowing him to join service, Lordship. But so far as the representation is concerned, Lordship, page 32. Without any sign, without any seal, Lordship. And stand of the authority is that this is never found in record, Lordship, this representation. So neither he is receiving any show cause notice, nor he is attending the office since 15/3/2019.
Now, what did you want?
His prayer is to join, allowing him to join service, Lord.
But have you suspended him?
No, Lord.
Not suspended.
He was in jail?
No,
Yes.
Lordship.
Yes.
He was in jail for 4 months, Lordship. After releasing from jail,
But isn't it the deemed suspension under 6(2)? When a person is in jail until further orders.
Yes. That is a deemed suspension. No, what happened, Lordship, although authority furnished the facts, Lordship. No parawise comments has been given, Lordship. I received this only on last month. Yes, last month, Lordship. But parawise comments are still.
No, my question, Mr. Naik, is you want to take,
Detention?
if anything is to be done, you have to take some steps.
Yes.
2019 onwards, you must have issued some show cause notice or something,
Yes.
or some memorandum of
Yes.
charge. He has not received it.
Not received.
So what has happened?
Lordship.
Unless you pass some order suspending him, how can you stop him from participating in the process or joining his duty? Something has to be done.
That is my submission, Lordship. Nobody has restrained him from joining service, Lordship.
Ah.
But he is claiming that he filed one representation in 2024, that is page 32. And stand of the authority is that is not in the record. So this is not found in the record, Lordship.
You were, what is the compelling reason you were absent?
Lordship, after discretion of the NIA and after when judgment was pronounced against him that he was going to some mental trauma, he locked him in a room, and family was tremendous suffered from him also. Then after that he was sent to jail. Then after that
Into?
jail, Lordship.
Jail?
Lordship.
Ah.
3 months. That after 3 months he also getting another 1 month. 4 months totally he went for jail.
But there is 4 months. You still have to explain another 55 months.
After 19 he was remain absent.
Understood. So 19 to 2024 is 5 years.
It's Lordship.
5 years is 60 months.
Yes.
So you have explained 5. What about the
Lordship,
remaining
that period
55?
Till he is mentally sick, Lordship, that period. But
Okay. So the next 55 months, he was mentally troubled.
yes, Lordship.
Then one fine morning, he wants to go and join.
Yes.
And they did not allow you to join. So the question is, without an order from the authority concerned, either suspending you or doing anything, you cannot be stopped from joining.
Yes.
That's your case.
Yes, Lordship.
So he is claiming that he has not been allowed to join. But we are saying that no, he never went to the office to join.
No, Lordship. He has verbally also requested many
This
times.
is the letter, Lordship will see. Where is the receipt? Where is the seal?
Actually, application was he had not received the receipt
I think-
copy of the main application. When the main application submitted, after that he went to that's
But isn't it required? The person is unnecessary absence. You need to do some action, take some action from the government.
Yes, on that aspect, Lordship, this instruction is not complete.
Lekhok. Heard Miss
M. Description.
so and so appearing on behalf of the petitioner. Mr. P. Naik appears on behalf of the Finance
Yes, Lord.
Department
One,
of the
two,
Government of
one and
Assam. You are appearing for which department? Mr. So and so appears for the PHE department. The grievance of the petitioner herein is that the petitioner on 12 wanted to join his services in the after an absence from March 2019 in the year 2024. But the respondent authorities did not permit the petitioner to join. In that regard, as representation was submitted on 12/4/2024, which was also kept pending, was not received,
It's received, but not, he had not taken any.
was kept pending. Per contra, Mr. P. Naik, the learned counsel appearing on behalf of the Finance Department, however, submits that the petitioner was nowhere in the picture from March 2019. And till date also, the petitioner has not appeared before the office. In that regard, the respondents have taken certain steps for issuance of certain notices and show cause proceedings, but no notice or show cause proceeding could be served upon the petitioner. He further submits that full stop. This court, however, inquired with Mr. Pinay as to whether any orders have been passed, thereby suspending the petitioner for his non-appearance, for non-attendance since March 2019. He submits that he would obtain instructions in that regard. Lists this matter again on 9th of March 2026. Affidavit be filed by the respondents on or before 2nd of March 2026. Liberty given to the petitioner to file reply. Okay, that's. Always. Mr. Roy Chaudhary, last item of the day.
I was always last one.
Yes, tell me.
Because I was officer in charge of the.
No
Pulverton
proceedings shall be
station.
carried out in terms of the show cause notice. What is this show cause notice?
My lord, I arrested one smuggler who was smuggling. I was officer in charge of a police station. Then during investigation, he tried to flee away. So my lord, finding no other alternative because he injured the constable, I fired him on his leg. There was a hue and cry, lot of newspaper report. On that basis, state accountability, Assam Police State Accountability Section passed an order that the DGP should take a disciplinary action and put a report before the state accountability. The DGP held that on that there is no misconduct because it is on his part of a duty. After that, it was sent to the state accountability. State accountability said nothing to it. You have to take a disciplinary proceeding in the state. That was when we approached this court against that order.
The state, what did he do?
Because that page, at page 28, it starts, but your lordship will find page 37, operative portion. That's state accountability, police state accountability. It starts at page 28. The page 30. State Police Accountability Commission. Direction at page 37, para 70. Accordingly, the commission directed DGP to initiate different responsibility personally. However, opportunity such and such, that was to the director, to the DGP.
Firing at the leg after warning should be recorded by the law for the.
No, this is so motor taken by the police state accountability. And at page 39, the DGP submitted that it is submitted the departmental or disciplinary action is warranted against in connection with such and such is. No departmental or disciplinary action is warranted against the Vajinti collector. That was the DGP submitted before the State Police Accountability Commission, page 7, first paragraph. But the State Police Accountability held that is at page 41, para 10. The DGP Assam is here.
So you are challenging the order of the State Police Accountability Commission. Who is appearing for the State Police?
Lordship, I am appearing for the State Lordship. Lordship on 5/12/2025, Lordship notice was issued and there was a certain restraint on the show cause that was issued, Lordship. But thereafter, Lordship, they have not taken any steps so that we can take any instruction. That today, Lordship, in the morning, I found all the letters that are lying because of the non-furnishing of the extra copies, Lordship. I could not have any information. And
steps taken. What?
And this was supposed to take within 1 week. And I have checked with the e-court also, Lordship. Nothing has been provided, Lordship.
No. The last matter of the day should be dismissed on this ground.
And I pray that the show cause that was, Lordship, some restraint was, it has to be vacated, Lordship.
We vacate all this.
That part is not my fault, but I don't know. It should have taken. But for one opportunity, first time it has come, Malad. One opportunity today, I mean.
Whole day I have not imposed any cost.
Malad, just 2 days holiday, Malad, at least we can enjoy that holiday without a cost.
10,000?
Malad, 10,000.
No. You have obtained a stay order. Either vacate the stay order or take the option 10,000 or vacate the stay order.
Malad, some cost with some kind of discount, Malad. That
It
much.
is. 10,000 is minimum.
Malad, 10,000, both the holidays will go, Malad.
No. Deposit Kolita, what is he doing?
Officer in charge of a police.
Oh, 25,000. He has shot somebody on the leg, na?
Leg man, on leg man, because he played him out and he was the smuggler. And by injuring the constable,
No, there shouldn't, there's 2 orders passed.
and their direction was given that he should initiate disciplinary proceeding.
This
And
has something to do this.
that was so moto, it was taken man by the state accountability, police state accountability on newspaper report.
See the allegation. Taking advantage of the darkness, the accused Sirajul Haq ran away with handcuffed and then SIR fired 2 rounds in the air to restrain him, but the accused did not pay. Finding no other, he had the 3rd round fired in his leg to restrain him, resulting in both injured so and so were taken to Golokar for treatment. On the so and so in his statement stated the matter on record as well as the remand. Veteran cattle smuggler. Oh, cattle smugglers.
Cattle smuggler. They was trying to play to Bangladesh.
These are reveals and so in the present there is no apprehension to life of the police officers so as to use this is only to carry out the investigation in fair and man having regard to the law and help drive regarding as per the and the acquisition of any use nature to affect the arrest at the time. Thank you, so already arrested is leading the police officials to show that cattle smuggling. And then taken in the fiber and prepare the repair. I think this is a case for dismissal. This is a case for dismissal. The facts are blatant. Here is a person who is handcuffed, taken to a place where he's showing a route. You say that he's running away, and as such you shoot him.
Because he
A
injured the
person who has 2 hands, or no, wait. A person who has 2 hands, which is at a free flow, there's no problem with it, compared to a person whose hands are tied.
one hand, sir, one handcuff with one hand, man.
What one hand?
Well, because he was carrying, constable was carrying him.
So, no, 2 hands. So therefore, he can't run much.
Because he injured the man.
Or maybe you are not that physically fit.
Because my lord, constable, he ran away from the constable, injuring the constable. It is that page, your lordship will find that finding that, my lord.
No.
Page 32.
How an accused can escape from the police
On the
custody
receipt,
under handcuff. Firing of 3 rounds in such situation is totally unjustified, rightly so.
Page 32.
Had the accused weapon in his hand and fled away by taking showing threat to the police with injury, life that would have been a different where the police may not dare to run after such person.
When the state accountability
Police-
directed the
A
DGP
person running while showing a this is bad. Why choose the night hours to trace the cattle smuggling route? Why did you go at night?
because we have caught him during night also. but he
No,
was
you
with the cattle
took him after arresting and took him at night. Kindly show me the cattle
because
smuggling
when
route.
During investigation, when he caught him. it
There
was
seems to be
darkness.
something. No, this is
Well,
not a
at
case.
Page 32, your lordship. will
No
find-
matter how much is the criminal background of an accused, use of firearms to an accused is the last resort.
my lord, then he could have fled away, my lord. Because
So, what heavens would have fallen then to kill a person?
my lord, I injured him in his leg, my lord. Not,
Ah,
I have not only injured him,
No.
I have not killed him, my lord.
if you would have died,
My lord, we have, after injuring him, we have taken him for treatment also. Page
that
32.
cannot be a ground. Article, it is rightly done. Initiate departmental proceedings against so and so.
But my lord, the
He's
DGP
on
said there is
behalf
no
of-
requirement. This is not. a
No,
requirement.
this is a case for dismissal. These are very blatant facts. What do you say? You are going to support him.
Page 43, no lordship.
You are going to support him
Ground,
because the government also wants
grounds
these people to
mentioned
be.
lordship.
Because she is not for the state
Ah.
accountability. She is not for state accountability.
And
But I am
and
the
you
main-
want to
yes.
escape getting an order of of the state accountability state out here
Lordship.
and not taking steps.
Well, that chapter, my lord. I,
So why not 25,000 cost?
25.
5,000? You are the eldest, so 15,000 upon you and 10,000 upon these two. 15,000 cost. I'm not extending the interim order. No steps
My
taken.
lord, everything will become infructuous, my lord. If your lordship.
Let it be.
My lord, then my
Let
lord,
it be.
little bit of cost, my lord, and the interim want to continue. So that.
25, not less than
My
that.
lord, 25 will be heavy, my lord.
25.
Because for not
25
this is the
is too
first time,
less.
my lord.
The
On
last
back-
day, you are spoiling another time out here.
My lord, it is the, my lord, first time it has come.
This 25, I'm telling you, will be distributed amongst all lawyers whose matters couldn't be taken up.
For the next time, my lord, I will keep on sitting over here if I can add something.
Yes, yes. Okay. It has been submitted that the steps, Ms. M. Bhattacharjee appearing on behalf of the respondents submits that only today steps have been taken.
No steps taken, Lordship, till date.
Uh,
These are all my signed because I keep this, Lordship.
Ms.
After
M.
that,
Bhattacharjee, the Learned Council submits that till date no steps have been taken.
She appears for 1, 3, 4, 5, 6.
yes, 1, 3, 4,
Though
5, and 6.
there was a direction passed by this court to take steps within 1 week from 5/12/2025. Considering the above, this court therefore does not find the present case to be a fit case wherein the interim order can be extended. Full list this matter again on 9th of February 2026. In the meantime, if steps are not taken, it shall be presumed that the petitioner is not interested in the instant proceedings. Full stop. Liberty is further given to renew the prayer for interim or directions on the next date, subject to steps being taken.
Deeply.
Item number 33 measure can say the implement petition measure. They stick by order measure.
Huh?
They was stick by order.
Implement.
Yes.
Okay. No.
Yes.
This is an application file.
Another one, Sri Pankaj Chaudhary, SCS, he is now assumed as Melot as District Commissioner of Kokrasar Melot. He is to implement in place of Melot earlier.
Implement of what?
Melot. Earlier Deputy Commissioner of Melot was implemented as.
Okay. This is an application file seeking implement of the implement of Sri Pankaj Chakraborty as the respondent number 3 to the accompanying contempt application. Mr. Counsel, tell me one thing. Whether this person concerned,
Yes.
Pankaj Chakraborty, knows that there is an order being passed.
Yes. No, Melot.
Then,
Earlier
no, you see, how do I issue notice? I may implead him, but I can't issue notice to him. Because you see, there has to be a willful and deliberate violation. To be willful and deliberate violation, there has to be also an information given that, look here, this is the order, kindly do the needful? How do I hold it? Issue notice to him. Tell me.
My lord, what happened, my lord, earlier, my lord?
Understood what happened, but the problem lies there. You cannot do that. See, problem is you cannot go there. Where is the order? Let us see the order. Become so easy. Sham so and so in view of the area, you have the
Another equipment return was filed, my lord.
What,
This was
where is the order of which you want to comply? Considering the above, the writ petition is disposed of by granting liberty to file an application before the appropriate authority. There, yeah. In the event the petitioner files an application, it is provided the respondent so and so shall consider and dispose of the application within 2 months. Isn't it the order?
My lord.
Then why do you need this application?
My lord,
The direction is given to the principal secretary BTC.
I have submitted, my lord. This has not been, my lord, appropriate, my lord. Thereafter, my lord, BTC authority, my lord, appeared before this court and my lord submitted that BTC authority has no role regarding, my lord, granting pensionary benefit as the subject matter is transfer subject to the, my lord, state government, my lord.
Then isn't it your order wrong? How can you maintain the contempt?
Thereafter, my lord, my lord, commissioner and secretary of PNRD, my lord, he is met party, my lord. He also responded, my lord. He appeared, my lord.
Mr. Counsel, tell me, you are asking for violation of which order?
My lord, order-
Violation of 29/5/2024,
Yes,
isn't
yes,
it?
Yes, sir.
29/2024 says, before the appropriate authority, that is the principal secretary BTC.
My lord.
There is no direction given to anybody else.
Yeah, yes, sir.
So under such circumstances, how do we comply this order if the BTC has no role? You have to seek a review to this order. The contempt proceedings is for execution. The contempt proceeding is not to give you further orders.
My lord, thereafter, my lord, again, I have approached before this court, my lord, by
Ah.
filing writ petition, my lord.
Then
In that writ petition, my lord, that order also I annexed, my lord, that is page 27, my lord, I will see.
supported the above content. Settle order where there is an order which has not been complied with, the remedy lies in Goa and not in here. No, this is different. Here, there was a direction to pass to the principal secretary.
Yes.
You say that within 2 months it has not been complied, for which you have filed a writ petition.
My lord. Thereafter, my lord, I have submitted a representation.
Kindly see the order, page 27 of Justice Shyam. Instituted the same writ petitioner by contending that although an earlier order passed by this court directing the principal secretary AR to consider the representation to be submitted by AR within a similar grievance within 2 months from the date of receipt, and notwithstanding the representation submitted by the petitioner, the same has not been considered until date in compliance. Instead of instituting a complaint, the writ petitioner has approached for the second time. So and so does not. It is settled law that when there is an order passed by this court which has not been complied with by the authority, the remedy lies in the contempt in view of the writ petition. But the facts is different what you are saying. That the principal secretary has said that he has no role.
Yes.
The role is of some commissioner and secretary. Now the commissioner and secretary, there is no direction. There cannot be a contempt against him. So the only way is you have to, therefore, taking into account their stand, seek a review. That is the only way out, Mr. Counsel. Contempt, we can't help you. Not only that, the application is wrong, IA is wrong, it's another aspect, but it is not going to serve your purpose. Your purpose can only be served if and only if you get an order against the person concerned, taking into account the stand which is being taken by the BTC now, that look here, we have nothing to do. So if they are saying, so therefore you ask the court to kindly do it because of the fact that this has happened.
Thereafter, my lord, content, my lord, Commissioner Secretary, my lord, Council PNRD, he appeared, my lord, and my lord issued, my lord, something statement that was also in the report, my lord.
What does he do?
9/6/25, my lord, with the communication measure, the Commissioner and Concerned Rural Development Department wrote the IC Secretary Gursheka Muhammad.
Therefore, the case of the petitioner referred to the Commissioner PNRD, the competent authority for taking action. In view of the above, we are requested to furnish necessary information as to whether the pension proposal of the deceased incumbent has been submitted to the Commissioner PNRD at the earliest. Then, Director PNRD.
Thereafter, my lord, nothing has been done.
Understood, but why you are making the DC?
My lord, this was IC Secretary Gursheka Muhammad is under my lord, District Commissioner. So my lord, I have
The council, this application is not maintainable. Today is this. I am dismissing your I. Tomorrow we will consider about the contempt. Full stop. This is an application filed for impleading one Sri Pankaj Chakraborty ACS, District Commissioner Kokrajhar, as a party to the accompanying contempt application. This court had duly perused the order dated 29/5/2024, passed in WPC number 2741/2024, wherein there is no direction upon the District Commissioner Kokrajhar to take any steps. Rather, the direction is only upon the Principal Secretary, BTC, to take appropriate steps. In addition to that, it is also seen that the petitioner have also not taken steps upon the said Sri Pankaj Chakraborty, District Commissioner Kokrajhar, by putting him to notice about the order dated 29/5/2024 in WPC number 2741/2024. Under such circumstances, without there being intimation being given to Sri Pankaj Chakraborty, District Commissioner Kokrajhar, about the order dated 29/5/2024 passed in so-and-so, the question of there being any willful or deliberate violation to the order passed by this court does not arise. Under such circumstances, the instant application cannot be permitted, for which the instant application stands rejected. So-and-so to be listed again on 9th of March. Short date, 16th February. Yes, any dates you want, you take it.